So I'm hoping for a good birthday present. Yeah, me too. This year would be the best birthday present. You're gonna ask about 100%. So you come back for a week to me. Okay, so Frank gets here, do you want me to announce something?
Yeah, just Tony's gotta wait. He's gotta wait.
Anything else that's been up to speed with?
I mean, no, just tell him that we're.
And we can, I can email them too. And just tell them I'll come out and get them when it's time. You can pick whatever you
I think I'm
want.
just gonna use.
Yeah, go ahead, Dave.
You're welcome.
You said things, I probably should have later. And when you have this, then you do it. Best.
So it's these ones.
Okay,
Which is.
that's right. Perfect.
So organized yet again.
So,
Just gotta get all my stuff organized yet again. It's hopping around.
like I said,
Yeah, that's what you. say that. He doesn't say that, but that's what the math works out to.
Not shy.
He's gonna have to present it, and say that's reasonable.
I read no. I read some.
Yeah. Turn to my client. Why are you paying me so little?
Right.
Um. if Judge pushes on it. There's no way. If the judge pushes on start, who wasn't? We have just put it first. If he waives. Thinking he's gonna like trip us up, I can just go.
Oh, I can.
Okay. He's mine's quick. So I'm
Then
okay
you
to
only
go.
gets John Bud, right?
Yeah, you would all, well, oh. But yeah,
Why would he do that?
he
I
won't.
can't imagine giving him close.
He's never gonna, I don't think so either.
He gets too
Unless
much
he
chance to
doesn't
strip
mention
us
stuff,
up,
but-
two more times.
Yeah, I agree.
I mean, I remember the judge said that, but I was like, yeah, right.
Right. Oh, I thought the same thing. Glasses, that'd be very nice. Sorry.
I like to see me. See, it's not-
Oh, yeah, there. Yeah.
So I just thought, so maybe they'll do this. It's just, yeah, no,
And come back. That's fine.
But from other.
Twice, just to make the joke, it's not.
Oh, oh, that's funny. Just what. You might have turned it on. Oh, it's working.
Yeah, it's okay. Can I come to this? Thank you. It's wrong. It's something. Oh.
Oh, here, right here.
I'd say, here, 5 minutes.
Will we come to order, any seating?
Any idea if they're here? They're all here? Okay. All right, we're back on the record. Mr. Derry, is there something else you'd like to address before we bring back the jury again? And I believe you rest.
Honor. There was that one, well, there's two slight issues, but one is, if you recall, one of the things that we mentioned was calling that phone number and it not being in operation in that letter to me. And we provided that number to Mr. Tobin yesterday. We also provided the affidavit, which brought this back up in January of, or sometime in 2012, 2013, years ago.
All right, what's your position on that, Mr. Tobin?
So I did get some information about that. The phone number was provided to Mr. Hadary in the letter dated July 20th, 2011. It's joint exhibit 81. And that phone number was decommissioned in April of 2012. So if Mr. Hadary found out about the foreclosure, tried to call that number, might very well have gotten that message. Problem is, it's totally not probative of anything because it was 9 months after the letter had been sent. So it proves nothing that a number that had been valid in July of 2011 was then not working in. So we don't think it should come in. And of course, we haven't had notice of this. It wasn't in the pretrial order. So we would object to any presentation. This notice.
That might be true, that it was in operation after 2012, but it wasn't working when I got that letter, when we had questions. And so that was an issue. Would have been very nice to be able to have someone explain it, but that number was not in operation at that time.
Okay, but the only way you're able to prove this is it hasn't been put to them in any pleading. It didn't come up in any deposition. It's solely you as a witness called the number.
It was a affidavit attached to a motion for summary judgment.
Okay.
And a response to a motion for summary judgment.
All right. Well, if you were the sole fact witness on that point, I don't see that as being permissible to prove that fact at issue. And so on that basis, I guess if this is coming in the form of a motion or however the procedural vehicle, if you've got some other way to present that as proof, then we could do that. But there's not been an offer to stipulate, and I don't think I can permit you to testify on that point.
Other issue that we wanted to bring up was 13611. We were going to go into it, and I believe.
Sure. Your Honor, I think there was a question on whether or not 13611, whether Wells Fargo was in default and thus liable for it as a matter of law.
No, that's not an issue. I already ruled on that. So I've said they're liable. They disagree. They'll get to go and convince the Court of Appeals otherwise. But that's not an issue.
Sorry, Your Honor, that was my understanding. They were disputing that and whether that should be included.
I already put that in the May order. That's what I was clarifying. Really, it was the verdict form that I have, which I have been told is the most recent one, I think still has Wells Fargo. Do you find them liable? So we'll just have to fix that when we look at that. All right. So the last thing being, you've asked for admissions to be essentially read to the jury. Again, thinking through this, I think we were started to run in circles, but looking at a case Versico 238 Georgia Appeals 837, which just simply says that if there's an admission relieves the opposing party from presenting any evidence, it's binding. And so even if the admission is not true, it still comes in. And I think that's what we keep circling around here. Wells Fargo and PNC both say that these admissions are not true, but legally they are admissions. So I would be pointing out that this is solely an admission on behalf of Wells Fargo, and the jury cannot impute this admission to PNC Bank or hold it against PNC Bank. But I think that the plaintiff has a right to have these admissions, if they are factual statements, presented to the jury. So, and that applied, as was highlighted, for paragraph 25 and 26. PNC can argue whatever it wants, and the jury will be instructed that it's not binding against them.
The identical admission in terms of whether or not they conducted foreclosure on behalf of Wells Fargo as well. So I know you just said it's just binding for Wells.
Just for the effect of the admission itself is what I would say. You can argue whatever other evidence came out.
Same admission on both for both parties, though.
Don't those paragraphs just speak to Wells Fargo?
So paragraph 25, in early 2012, Wells Fargo foreclosed on the property without a recorded interest in the property. No, so I'm not quite sure.
The other one, Your Honor.
And then the next one is on or about February 15th, 2012, PNC Bank sold, assigned, and transferred its right to the security deed to Wells Fargo that was filed and recorded.
Okay.
Your Honor, just for the record,
Sure.
I'd like to reiterate that none of this was raised in the pretrial order. We weren't aware that this was going to be an issue. Had we been aware, we would have addressed it with our witness. I think that this is another example of trial by ambush, and it's fundamentally unfair. And Mr. Hadari should not be able to litigate like this without there being some consequence for his actions. It's not been the first time that he's taken an attack like this.
Just to complete the record, what would you have done with your witness had you known that these two were just going to be read to the jury?
I would have addressed with my witness the fact that there were answers made that there were responses in the answer that were later determined to be incorrect, that the answer was filed in a rush because we were in default and something had to be filed quickly. And that as soon as somebody really took a look at it and figured out the answers, we corrected that. Obviously, the jury hears that we know the correct answer now, but they didn't get any of that color. It's just going to be read to them like this was admitted.
You know what, Your Honor?
And frankly, Your Honor, we've defaulted. So the jury's going to get instruction on the default and the fact that we've admitted to wrongful foreclosure as a legal matter. So this is completely unnecessary.
Right, but I don't think someone's prevented from proving their case if they need to tell the story of it. And what I hear from you is that you wanted to have the opportunity to come back and then later prove these as false, which again, I think is not what legally an admission can do.
Want to put PNC's joining the objection on the record. The second of those paragraphs does speak to PNC. We had an opportunity to have a witness here for PNC. He's been excused. This came up very late, but after he's gone. So it's unfair, wasn't in the pretrial order, so we think it should not come in. We object on that basis.
All right, so noted. Mr. Hadari, did you have something else you wanted to add that's relevant to this? Okay, so all I'm hearing then is that you wish to read paragraphs 25 and 26 to the jury when they return.
I can read them, or we can give them as instructions or you can read it to the court. I mean, to the jury. Either one's fine with me, Your Honor. And I've had judges do different things.
I'll just, like I mentioned, I'll give a limiting instruction before you do that, and then I'll allow you to read those two admissions.
Just to make sure I'm entirely proper, the ones you just allowed are paragraphs 25 and 26.
Those are the ones you asked about, so.
I mentioned towards the end I had some more, but my time was up, so.
Well, if there's something you think is material here, this is your chance. And how are we doing on Mr. Tobin on your witness?
Here.
All right, we want to go ahead and bring him in.
Well, we've got our motions.
Is that something we can reserve until after his testimony? Just so the jury isn't sitting back there for, an extended period of time?
As long as there's. Yeah, I mean, right, I think we would need plaintiff to state on the record that the fact that we're doing it out of order would be, waived and wouldn't create any issues later. If he's not prepared to make a very clear waiver on that point.
Understand, Ms. Tobin. Any objections on your end, Mr. Hadari, to going out of order as to when they can make their motions?
I explicitly waived that.
All right, so we can do that closer, maybe combine it with the charge conference, just so we can tell the jury, hey, we need a good hour, hour and a half. All right,
The other paragraph was number 39, Your Honor.
all right, 39 just simply says defendants PNC and Wells Fargo foreclosed on the property.
You really need that.
And
Business.
well,
If that's still an issue, then we're in trouble.
what's even more explicit though is Wells Fargo's answer, where in response to the allegation contained in this paragraph, Wells Fargo admits Wells Fargo foreclosed on the property through his agent and attorney, in fact, PNC Bank. And so I think,
Your Honor, this needs to end. Every time you ask him, he comes up with, oh, well, now we need to talk about this paragraph. We need to talk about that paragraph.
All right, you said 39.
that's their answer. Yes, Your Honor.
You can read 39, which is from your complaint,
It's-
is deemed admitted by Wells Fargo.
But it's also what I just said was their answer that I quoted verbatim. So
They didn't answer though. They didn't answer. They defaulted.
trying to file a affidavit.
This has got to.
No, that's okay. It's okay. That's not happening. You can read that admission 39 and we can go with it. But that answer wasn't in response. The only-
Let's start over again.
Well, this
Yeah.
just for purposes, Your Honor.
Yeah.
And this is one of our issues that would, that's caused us so much anxiety and angst was after the property was transferred, Wells Fargo filed a motion to open a default. And one of the conditions to doing that is you have to actually file an answer under oath and say you're ready to go forward.
I got you. But then that was denied, right?
The motion was denied, but their pleading, which they submitted under oath, their verified pleading, said specifically in response to our allegations of the complaint, Wells Fargo admits that Wells Fargo foreclosed on the property through his agent and attorney, in fact, PNC Bank.
I hear your argument. And if you've got a case directly on point, I'll hear it. But otherwise, my initial reaction would be that that answer was never accepted as an answer, that the motion was denied, even though it was attached to the motion to reopen default. So it never formally became an accepted pleading on the docket.
I believe it's still,
Make that same point, Your Honor. Thank you.
I believe it's still pleading, even if the court denies it. So if I filed a motion to say, you know what, I want permission to go leave court in the middle of trial and the court denies it, and then I do it anyways, you can still come back and say, you know what, in that pleading, you specifically made this factual assertion, and therefore I'm holding you in contempt or all that law we talked about.
All right. Well, your objection is preserved for the record. And so we're going to stick with 25, 26, and 39 with the limiting instruction that I mentioned before. Anything else?
Your Honor, so I'm just gonna read the paragraphs and just say the Wells Fargo explicitly agrees to these statements.
No, just reading the paragraph.
You're just gonna read them. Just gonna read them. I'm gonna give the instruction that Wells Fargo has made the following admissions that they are not to be held against PNC. All right. Okay. And then I believe plaintiff would rest. So why don't we go ahead and just have your witness come on in if you'd like.
No?
Yeah, I think that's only gonna take a minute and we can go ahead and keep moving forward. If we could bring back the jury.
Your Honor, just for the record.
Yes.
And just I want to make sure that things are clear if there's an appellate issue. I was trying to have for 25, 26, and 39, I was trying to read in Wells Fargo answers that they submitted under oath, which were attached to their motion.
Right. I think you've already made that clear.
I'm just making sure.
Yeah,
That's all.
it's the answer that was attached to their motion to reopen default. All right. And the paragraphs from that answer, did you, why don't you go ahead and make that clear?
Thank you, Your Honor, would be the corresponding answers to those paragraphs, which are 25, 26, and 39.
Okay.
Yeah, Frank, you're supposed to sit in the box for now. We got a little bit of work to do, but then we'll get to your testimony shortly.
Staying tight. We'll be right with you. Thank you, Deputy Scott. Thank you, members of the jury. Everyone, please have a seat. Members of the jury, the plaintiff has requested to present admissions made on behalf of Wells Fargo. As I explained to you at the outset of this case, because Wells Fargo failed to timely file and answer their admitted liability, as well as certain statements of facts. These statements of facts that are about to be read to you should be held solely against Wells Fargo and not against PC or for any other purpose. So, Mr. Hidary.
Two admissions I want to read to the jury, which is that in the instant case in early 2012, apparently Wells Fargo foreclosed on the property without a recorded interest in the property. And what should also be clear at this point, but we will simply state so for the record, is that defendants PNC and Wells Fargo foreclosed on the property. Thank you.
All right. Plaintiff may call their next witness.
Need to refresh your honor.
All right. The plaintiff has rested their case in chief, which now gives the defendants the opportunity to present evidence if they'd like to. Any evidence on behalf of PNC?
Yes, sir. Your Honor, I'd like to call Frank Olson.
You could swear in the witness, Deputy Scott.
Raise your right hand for me. Do you swear affirm that the testimony that you give in court is the truth and that's what the truth so help you?
I do.
Would you please state and spell your first and last name? What?
Yes, Frank Olson, Olson. My first name is Frank, Frank.
Good afternoon, Mr. Olson.
Good afternoon.
Mr. Olson, can you tell the jury what you do for a living?
I'm an attorney here in Georgia.
You're a member of the Georgia Bar?
Yes, I do.
Can you tell the jury how long you've been a practicing attorney?
I think this is my 28th year of practice. I know I don't look that old, but I am. Yes, I'm sorry. Thank you.
Can you please describe briefly what kind of law practice you currently have?
So currently I have my own firm and we practice primarily community association law and other real estate law matters.
Can you describe just very briefly what association law entails?
So primarily it's representing homeowners associations, both in litigation as well as transactional work. So I advise them about things like their covenants and how to amend those and various procedures for holding meetings, kind of the gamut.
Was there a time, Mr. Olson, when you practiced with a firm called McCurdy and Candler?
Yes.
When did you practice with that firm?
I began at McCurdy, I believe, in December of 2005. And I left that firm in June of 2014.
Can you describe the general nature of your practice when you're at McCurdy and Candler?
Yes, I headed up the litigation default practice group. So what that entailed was representing lenders and servicers in litigation matters involving mortgage loans, foreclosures, evictions, title curative work, that sort of thing.
So you were the manager of the default litigation practice at the firm?
Yes, I was.
Approximately how many attorneys and paralegals and other staff did you supervise in that capacity?
As far as attorneys, I think we had maybe 4 attorneys and maybe 4 to 5 paralegals on staff.
Did you become familiar with foreclosure procedure in Georgia?
Yes, I did.
Can you estimate approximately how many foreclosure matters your firm handled during these years? And in any way that gives the jury some sense, whether monthly or annually, or however you want to answer the question.
So probably on average, McCurdy and Candler handled approximately 2,000 foreclosures per month during that 9-year span that I worked for them. Some months obviously more, some months less, but I think that's probably a good average.
Okay. Did McCurdy and Candler operate throughout the state of Georgia?
It did.
What kind of clients did McCurdy and Candler represent?
Primarily, we represented what's called mortgage servicers. So those are the entities that basically kind of do the day-to-day workings on a particular loan, taking in payments, referring those matters out for foreclosure when the loan fell into default, that sort of thing.
Was PNC one of the mortgage servicers that was a client of McCurdy and Candler?
Yes.
Can you describe what the procedures were generally for receiving referrals of foreclosure matters from clients such as PNC.
Okay. So generally speaking, we were, I guess for lack of a better phrase, logged into an online portal, and the servicers were as well. And so what would happen is if a loan fell into default and was referred to the firm for foreclosure, there would be an electronic transmittal of certain loan information with a request that that loan be, the process be started for a foreclosure.
Can you describe for the jury sort of the basic important information that was delivered to you by PNC and other clients in order to start a foreclosure referral?
Yes. So we would receive the date of the loan, the amount of the original loan, the amount that the loan was, that it took, for example, to pay off the loan. Likely we would have received reinstatement information as well, the amount that would be needed to reinstate the loan, when the borrower fell into default, when their last payment was. We would receive the property address for the property in question, as well as if there were an additional address that we had been provided, we would receive that as well.
Was it necessary for McCurdy and Candler to provide notices of various sort when starting a foreclosure matter?
It is and was, yes.
Can you describe for the jury what the notices were that McCurdy and Candler was required to provide?
Certainly. So first, we were required by federal law to send what's called a initial communication letter whenever we are initiating contact with a homeowner. That's a federal law that governs our conduct when we start that, so we'd have to send that notice. In addition to that federal law notice, we also had to send a notice of the foreclosure sale to the homeowner. And then I guess the third notice would be the notice of publication. We had to publish that notice of sale in the local newspaper in the county.
Is there a particular Georgia statute that prescribes what your law firm was supposed to do when giving notice to a homeowner?
Yes. So the the state statute is OCGA 4414-162 and following.
Your Honor, if I may, I'd like to put that up on the screen and see if Mr. Olson can identify it for us.
Objection. All right.
Is this the statute you were referring to, Mr. Olson?
Yes, it is.
Can you describe without reading the words, but just
Mhm.
describe for the jury what this statute requires?
So this places a duty on us to advertise the property for sale, as well as conduct the sale itself in compliance with Georgia law. And specifically, there's a subsection of this statute that we're looking at that more specifically talks about the notice that's required.
Can you describe for the jury what McCurdy and Candler typically did to comply with this statute?
What we would do is we would draft a notice of foreclosure sale, which contains the required information in a letter form. We would send that both by certified mail as well as regular mail, although regular mail wasn't required. We sent it both ways, both to the property address as well as to any additional address that we had on file for the homeowner. And in addition, we would, as I mentioned before about the publication, we would also begin that process by contacting the local paper and sending that notice of sale to them to begin publishing it in the local newspaper for, it's basically once per week for 4 weeks.
Can we pull up Exhibit 97A, please? If we could go to the third page, please. Mr. Olson, this is a document that has been admitted into evidence in this proceeding. Do you recognize the document that you see there on the screen?
Yes, I do.
Can you tell the jury what this communication is?
As mentioned, this is the initial communication letter that our firm sends whenever we initiate a contact with any homeowner who is facing foreclosure.
Right. And is this, you mentioned there are two different notices that are sent.
Yes.
Can you remind the jury what the two notices are and tell them which this is?
Okay. So this is the notice that's required of us by federal law. This is not the actual notice of sale letter that's required by state law. But this will provide the homeowner with certain basic information, such as the name of the creditor, the amount of the debt. It also gives them notice of their rights under federal law to dispute that debt within 30 days. And it also provides contact information. It looks like for our firm, and it may also provide contact information for the servicer so that the homeowner can reach out once they receive this to see if anything can be worked out.
Was this an initial communication letter that was in fact sent by McCurdy and Candler on the reference date?
Yes.
Okay, and are there pages within this exhibit, such as the first one we looked at, that might help you confirm that?
It would. I don't know if you want to go back there. I can.
Yeah, let's go back to the first page, please. The other way, back to the first page of the exhibit. One more. There we go. Mr. Olson, do you recognize the information that appears on the first page of Exhibit 97A?
I do.
Can you summarize for the jury what information is depicted there?
Yes. So this is a record of McCurdy and Candler's mailing of this notice that we've talked about. McCurdy and Candler used a third-party vendor called Walls, W-A-L-Z, to handle all its mailouts. And so they would create this. This is actually a record they created, but we would also keep it in our records. And this provides notification of when for example, when our information was sent over to Walls to begin the mailing process. That's the first date, January 21st of 2012. And then moving up from that list, it shows basic information about what happened in between us sending the information to Walls and I guess the final action on the file, which would be an unclaimed letter.
And what was the ultimate, so the ultimate disposition was that the letter was unclaimed?
Per this document, yes.
Can we look at the last page of this exhibit, please? I guess one before then, where we got the, and if we could rotate it. Mr. Olson, do you recognize the information that's presented on this page of Exhibit 97A?
I do.
What is this page of Exhibit 97A, which bears Bates number PNC 569?
This appears to be a copy of the returned envelope that was received back from Walls.
Is there information, I'm sorry.
After the mailing time had gone through, yes.
Is there information on this page that indicates what happened to this particular notice?
There appears to be, yes.
What does that information tell you?
And that's at the bottom right. It appears that there was some type of forwarding instruction given to the post office, and the forwarding time had expired. It is cut off, but it says return to, and I believe that probably should say return to sender.
Very well. Can we pull up Exhibit 97B, please? Let's go to the first page of the letter. Mr. Olson, we're looking at PNC 573, which is the third page of Exhibit 97B. Can you explain to us what we have here?
I think this is the same letter that we've been talking about.
Okay. Can we look at the first page of this exhibit? And my question to you, Mr. Olson will be, can you see if there's any difference between 97B and 97A?
Just,
Direct your attention to the recipient,
okay.
the upper. And you might need to look back at,
I see.
Okay.
So there is a difference. This letter apparently was sent by first class mail to a PO box.
can you explain, so fair to say that the federal law letter that was sent by your firm on January 20th was sent in 2 envelopes
Yes, that is correct.
to 2 different addresses?
Yes, correct.
Can you explain why it was that it was sent by first class mail to the 2 different addresses?
Certainly. So we had the property address right from the referral, and so we would always send any notification to that address. In addition, my understanding is when the matter was referred to McCurdy and Candler, an additional address appeared on that referral for this PO box. Accordingly, we sent our notice to that additional PO box.
Was it necessary under Georgia law to send the notice to both addresses?
Not to my knowledge, no.
Can you explain why McCurdy nonetheless sent it to 2 different addresses?
Because we want to do everything we can to get that notice in the hands of the homeowner.
Can we look at Exhibit 97C, please? And why don't we pause at the first page? Mr. Olson, can you explain where this notice was sent and by what means?
This notice was sent by first class mail, and it was sent to the property address.
Okay. And can you tell what the disposition of 97C was?
Per this record, it appears that this letter was unclaimed.
Can we go to the 3rd page of the exhibit, please? Okay, Mr. Olson, let's take our time with this one. Can you explain for the jury what this page, which is PNC 594, depicts?
Yes. So this is the actual notice of foreclosure sale that I discussed. This is required by state law to be sent to the homeowner, notifying them that their property is going to be sold at foreclosure. It also, of course, provides some information about how to contact the servicer with respect to this. This also contains the notice of sale that we sent to the publisher.
All right, I just want to take each of those at a time. So do you see the part that's in italics with 3 asterisks below the re section?
Yes, I do.
Just want to read that for you. Pursuant to OCGA Section 44-14-162.2, the following is the entity who has full authority to discuss, negotiate, or change all terms of the mortgage with you concerning the foreclosure alternatives described later in this letter. Did I read that accurately?
You did.
Am I correct that PNC is then identified as the entity referenced there?
Yes.
Can you explain for the jury why this information is included on the first page of the McCurdy foreclosure notice?
This is included because the statute required it to be included in our notices.
What's your understanding of the statutory requirement? What needs to be provided?
That the homeowner needs to be provided the entity that can negotiate the terms of their loan, and also provides, there's some other things in this notice, including, the anticipated sale date, their opportunity to contact someone to discuss prior to that foreclosure sale taking place.
There's also a reference there to the creditor, Wells Fargo Bank NA GSR 2004-12.
Correct.
Is that an item of information that the statute requires to be provided?
I think so. I'm not entirely certain, but I think at a minimum, what we had to do was we were required to provide them with the notice of who can negotiate their loan.
Okay. Below, dear sir or madam, there's a reference to by letter dated January 20th, 2012, the initial communication letter, the recipients have been notified. Is that a reference back to the federal law letter?
Yes, it is.
Okay. Can we go to the second page, please? Did this notice advise the recipient of when the public sale of the property was going to happen?
Yes, it states March 6, 2012.
And was that actually the foreclosure sale date for this property?
That's my understanding.
Can we go to the last page of this exhibit, please? And if we could rotate it. So how was this particular notice sent? You can tell, we can go back to the first page if we need to, Mr. Olson.
I think this is the one that got sent by first-class mail.
Okay.
Because the number there is different from a certified mail notice that I'm familiar with.
All right. And can you tell the jury what the disposition of this particular foreclosure notice was?
Appears that this notice, there was an attempt to forward it to an additional address, and that forward time had expired, and therefore the letter was returned to sender.
All right, can we go to Exhibit 97D, please? First page. Okay, from this page, Mr. Olson, can you tell what kind of notice we're looking at and how it was sent and where?
So this is again a first-class mailing notice. It was sent to that PO box in Alpharetta that we've discussed. And as far as disposition, it was also an unclaimed letter.
Okay. And can we go to the last page of this exhibit? While we're pulling that up, Mr. Olson, is the contents of 97D identical to 97C, except for the address?
Yes,
Were both of the addresses provided to you by PNC, or to your law firm, I should say?
yes, they were.
Were those the only two addresses that were provided by PNC?
Yes.
Okay, looking at the last page of Exhibit 97D, can you explain what we're seeing at page PNC 604 and how this particular notice was, what happened to it?
Yes. So again, this is the notice that went to the PO box in Alpharetta. And it says, I believe, return to sender, not deliverable, as addressed, unable to forward.
So as far as you know, this document was returned to the Walls organization because it was unable to be delivered?
That's correct.
We look at 97E, please. Let's see, let's go. Is that the first page of, yes, it is. Next page, please. Mr. Olson, can you explain to us what we're seeing here for the first page of 97E?
From the first page?
Uh,
I think you're on page 2, but
Thank you very much. Second page. It's
um,
been a long week,
I'm sure.
but thank you.
So this is, again, the notice of foreclosure sale. This is the one that was sent to the property address at 700 Latour Drive in Atlanta, containing the same information that we've discussed.
Okay, and can you tell what the disposition of this notice was? I suppose we'll have to go to a page further down, won't we? Page 583, please. That's it. So what was the disposition of this particular notice?
It appears, it says forward time expired at an old Alabama address in Alpharetta, and finally returned to sender.
So does what's highlighted on the screen now, Mr. Olson, indicate that the Postal Service attempted to forward this to PMB 289, 3000 Old Alabama Road, Suite, cutoff, Alpharetta, Georgia 30022?
Correct.
Does it also appear that the post office was unable to get this document to that address?
Yes.
Okay, let's take a look at 97F, please. go to the next page, please. Can you tell from looking at this, Mr. Olson, how this notice was sent and to where?
I think if you go back to this page, this would show that this notice was also sent by certified mail to the PO Box in Alpharetta.
Okay, and how was it sent, if you can tell?
I believe by certified mail, given that barcode at the top.
If we look at, can we look at the last page of this exhibit, please? It's PNC 590. Does this page, PNC 590, indicate the disposition of Exhibit 97F?
It does.
And what was that?
It appears it was returned to sender, unclaimed, and unable to forward.
With these, if we now looked at all of the copies of the initial communication letters, the 2 copies, 97A and 97B, and the 4 foreclosure notices that were sent, 2 by certified mail and 2 by first class mail for this particular foreclosure sale,
Yes, I believe so.
did the foreclosure sale proceed as scheduled on March 6th?
It did.
Did the notices that we've looked at so far today, Mr. Olson, comply with Georgia law as far as you know?
As far as I know, yes.
Can you explain for the jury why it was that these notices complied with Georgia law?
Because Georgia law requires certified mailing of these notices to the property address or to an additional address if one is designated by the homeowner or borrower in writing. And so based on what I've seen, I see a notice going out by certified mail, both to the property address and to the additional address that McCurdy and Candler was provided, that PO box. And as I think we stated, it went a little bit further because we sent it also by regular mail when there's no statutory requirement to do that.
Does Georgia law require that this foreclosure notice actually be received by the addressee?
No.
You tell us where in Georgia law that requirement is. That requirement is to mail the notice, but not that it necessarily be received by the owner.
I believe that's 4414-162.2.
We have access to that statute. Can you pull that up, please?
Yes, 4414-162.2.
Mr. Olson, I'll ask you to take a moment to review this statute and tell us if that's the statute that you have in mind here.
Yes.
Okay, I'd like to read it sentence by sentence and talk about each sentence. Okay, so subsection A, notice of the initiation of proceedings to exercise a power of sale on a mortgage, security deed, or other lien contract shall be given to the debtor by the secured creditor no later than 30 days before the date of the proposed foreclosure. Can you explain how it was that the notices we just looked at complied with that requirement?
Certainly. So first, the notice was given to the debtor, in this case, Ms. Song. And it was given more than 30 days prior to the date of the foreclosure. As stated, we had set a date of March 6, 2012 for that foreclosure sale. The letter in question was dated January 20th.
Second sentence reads, such notice shall be in writing, shall include the name, address, and telephone number of the individual or entity who shall have full authority to negotiate, amend, and modify all terms of the mortgage with the debtor, and shall be sent by registered or certified mail or statutory overnight delivery, return receipt requested, to the property address, or to such other address as the debtor may designate by written notice to the secured creditor. Did I read that correctly?
You did.
Can you explain how it is that the notices we looked at complied with those requirements?
Certainly. So again, the notice was, of course, in writing. As you mentioned, it included that italicized information about the name, address, and telephone number of the entity that had the authority to negotiate the terms of the mortgage. It was sent by certified mail. Return receipt requested to the property address. And again, it was also sent to an additional address provided to us by PNC.
Is the sentence we just read, Mr. Olson, the one that requires McCurdy and Candler to identify PNC as the servicer with whom Ms. Zong can negotiate?
Yes,
Would you also agree that that sentence does not require McCurdy and Candler to identify the secured creditor itself?
yes,
Okay, the next sentence, the notice required by this code section shall be deemed given on the official postmark day or day on which it is received for delivery by a commercial delivery firm. Can you explain how it was that the notices we looked at, Mr. Olson, complied with that sentence?
certainly. So as I understand, the notices were received for delivery. It looked like possibly on January 21st, but in any event, they were postmarked. So I believe it complied with that particular sentence, yes.
Is this a sentence that indicates that receipt by the addressee is not required by Georgia law?
Correct. There's also case law on that, but yes.
And then the final sentence, nothing in this subsection shall be construed to require a secured creditor to negotiate, amend, or modify the terms of a mortgage instrument. Did I read that accurately?
You did.
Okay. And then subsection B, the notice required by subsection A of this code section shall be given by mailing or delivering to the debtor a copy of the notice of sale to be submitted to the publisher. So what's that requirement, Mr. Olson?
That requirement simply means that we need to include a copy of what we send to the paper to be published in this particular notice that we send to the debtor.
And if we could look at 97, let's see. '97E, please. E is in Edward. And go to page 97E-004. Do you recognize the page that we see on the screen here, Mr. Olson? It's page number JX 97E-004.
Yes, I do.
What is that?
That is a copy of the notice of sale under power that was sent to, I believe it was a Fulton County Daily Report at the time for publication.
And was this page actually included in all four of the foreclosure notices that we've looked at?
Yes,
And was this in order to comply with that statute that we just read?
yes.
Can we look at 97G, please? Mr. Olson, can you tell us what we're seeing at 97G?
This appears to be the publisher's copy of the notice of sale under power that was sent to them for publication.
What is the Fulton County Daily Report?
My understanding that's, at the time at least, it was the official legal organ or legal newspaper for all official notices to be sent and
Is
published.
that the publication that McCurdy and Candler used to publish foreclosure notices in compliance with Georgia law?
Yes,
Is the form that we see here of the notice of sale under power consistent with the form that McCurdy used for its foreclosure sale notices?
it is, yes.
We'll look at Exhibit 98, please. Mr. Olson, can you tell us what we see depicted here?
Yes. this appears to be the record from Walls with respect to not only the subject property we're talking about, but a number of other properties. As I mentioned, Walls was the vendor that our firm used for its official mailings. So this is going to be basically a log or record of all of those particular mailings that Walls did at a particular time, including this one.
You see the reference at the bottom, toward the bottom of the first page where you can see Ms. Zong's name.
I see that, yes.
Can you explain for the jury what information is depicted there?
This indicates the 2 certified mailings were handled and received and sent out by Walls with respect to those addresses that we mentioned, the property address as well as the P.O. box.
Move the admission of Joint Exhibit 98.
No objection, Your Honor.
98 admitted.
Mr. Olson, are you familiar with the term AOM from your days at McCurdy and Candler?
Yes, I am.
What does that acronym mean?
That means assignment of mortgage.
Was there an assignment of mortgage that was necessary in this instance to proceed with a sale?
Yes.
Can we look at Joint Exhibit 101, please? Mr. Olson, can you explain for us what we're seeing here in Exhibit 101?
Yes. So this document assigns the security deed, which was being foreclosed upon, from PNC Bank to Wells Fargo Bank NA GSR 2004-12.
Did your firm play a role in preparing this document?
Yes, we did.
Did you rely on information from PNC to prepare this document?
Yes, we did.
Was this necessary to prepare and record before proceeding with the sale?
Yes, it was.
Are the signatures that appear on the document below PNC signatures or McCurdy signatures?
Those appear to be PNC signatures. I don't recognize anybody listed there as a McCurdy and Candler employee or agent.
Move the admission of Exhibit 101.
Objection, Your Honor.
None, Your Honor.
101 admitted.
Are you familiar with the term bidding instructions?
Yes, I am.
Can you explain for the jury what bidding instructions are?
Yes. So once we receive a referral for foreclosure, we will be instructed to begin the bidding on that property at in a couple of different ways. Number one would be what they call a specified bid. And what that means is that notwithstanding how much is owed perhaps on the loan, the lender or servicer has done an analysis to indicate how much they want to start the property selling for at the courthouse steps. So that's a specified bid. The other one would be typically what we called a full debt bid, which would be we would start the bidding at the total amount of the debt that's owed on the property at the time of sale.
Does Exhibit 104 appear to be the bidding instructions for this particular foreclosure sale?
Yes.
And which of the two approaches did PNC follow in this instance?
It appears a specified bid was used for this particular sale.
And can you describe for us the information that appears on the first page of Exhibit 104?
Yes. So this is a instruction sheet that would actually go to the person crying out the sale on the courthouse steps. And it would list things such as our firm's client, our firm's file number, the borrower's names, the property address, the lender in question, the type of loan. In this case, it was conventional. And so in connection with this, once the sale was cried or the property was sold, the crier or person crying the sale would have to indicate who bought the property at the sale, whether it was taken back by the lender or it went to a third party, and what time he or she cried the sale. And then you can see at the bottom the crier, that's Jessica Price, another attorney at McCurdy and Candler was the one who actually cried this sale on that date.
Move the admission of Joint Exhibit 104.
No objection, Your Honor.
Objection, Your Honor.
Admitted.
I have no further questions. Thank you, Mr. Olson.
Thank you.
Let's go in order of the caption. So Mr. Howard, any questions on your behalf? Half of Wells Fargo.
Mr. Olson, good afternoon.
Good afternoon.
I'm not sure if we've met. My name is Dylan Howard. I'm here on behalf of Wells Fargo.
We may have,
I feel like we have, but
I
in any
recognize your
case,
name. It's been a minute, but yes,
good to see you again anyway.
good to see you.
I just have a couple of questions. So you testified that McCurdy and Candler was retained by PNC to conduct the foreclosure sale at issue,
That's my understanding.
and that PNC provided a couple of addresses to McCurdy and Candler so that McCurdy and Candler could provide notice to those addresses about the foreclosure sale.
That's right.
So it's fair to say that Wells Fargo did not retain McCurdy and Candler to conduct the foreclosure sale.
Not to my knowledge.
Objection, Your Honor. Looks like we're going into liability.
I think it could also be interpreted as going to damages. Overruled.
Thank you, Your Honor. It would also be fair to say that Wells Fargo did not provide addresses to McCurdy and Candler for the mailing of foreclosure notices.
No.
And there were a couple of documents, the AOM, the bid sheet, one or two others, that listed a name that said Wells Fargo Bank NA GSR 2004-12. I believe your testimony was that was information provided by PNC.
That is correct. Yes.
So that would not be an indication that Wells Fargo retained McCurdy and Candler to conduct the foreclosure, because they did not.
Right.
Right, thank you. No further questions.
Any cross-examination?
Good afternoon.
Good afternoon.
My name is Yasha. I represent the plaintiff. We've never met. It's nice to meet you.
Good to meet you.
I just have a few questions for you. And you don't work for PNC, do you?
No,
You actually, who do you work for?
I have my own firm.
McCurdy and Candler?
No,
Oh, no?
it's Cobb, Olson, Anderley.
I want to step back to when this foreclosure was conducted, when 2012. 2012, were you working for PNC?
No.
Is that when you were with McCurdy and Candler?
Yes.
And when McCurdy and Candler sends these foreclosure notices out, it sends them out on behalf of PNC, right?
On behalf of the servicer who hired us. Yes.
And let me just, let's pull up 143B. And so just to, no, let's go back to the actual letter, please. So if you look here at the letter, it basically says law office of McCurdy and Candler, and that's the law firm you work for. And let's scroll down a little bit, a little further. And over here in the body of the letter, you mentioned that by letter dated January 20th, 2012, I notified you that the above reference creditor has referred the reference loan to this law firm for handling. And so you're basically advising the borrower at that point that the law firm's the one that's handling mailing of these notices and providing notice, the foreclosure process. Is that a fair characterization?
Yes.
And I believe Mr. Tobin and Mr. Howard made it clear that the information that you end up using in your process is really just provided by, for our case, from PNC. Is that a fair characterization?
Yes, it is.
Let's pull up JX 111. Let's go to page 502. All right. And let's scroll down a little bit. These are records from McCurdy and Candler, that correspondence between the parties. Is that a fair characterization of what's going on here?
Well, just to be clear what this is what they call CaseAware, which is McCurdy and Candler's system that I'd mentioned before, where we receive the referral information from the servicer. It also contains a record of interactions, if any, with the homeowner and our firm.
So in terms of what we're looking at here in the first note, is it fair to say, and perhaps I'll jump to the bottom, there's someone there named, it looks like a Miss Campbell, S. Campbell at McCurdyandCandler.com. Would she be someone, or he working for McCurdy and Candler?
That's my understanding, yes.
And if we scroll up, I just want to read the body of what we have here. So it looks like at this point in time, Ms. Zong is sending an email to Ms. Campbell, who's at your law firm. And she's saying, and let's read this. Actually, you know what? Let's skip the prior one, but you are right. We called in numbers. They answer, but they do not explanations in regard to how they come up with these numbers. I have been making my payments on time since the origination date, 2004. But since the escrow was established on my mortgage, everything become confusing. I have been disputing the escrow setup since last year. I will call Aaron Fisher. I thank you for providing the informations, Fei Zong. You would agree that that looks like an email that Ms. Zong most likely sent to your law firm.
Yes.
And in such a situation, would McCurdy and Candler be the one that actually does the analysis, or are they simply relaying information from PNC to Ms. Zong?
We would be relaying that information to PNC.
So if we scroll up a little higher and we see in the note, it said emailed reinstatement figure, and let me know if my interpretation is correct.
Mhm.
Emailed reinstatement figure to BWR, which I assume is borrower, in the amount of $38,000 and $40, including fees, in the amount of $960. Would you concur that McCurdy and Candler probably providing a reinstatement figure to Ms. Zong?
That's what this note indicates, yes.
Would McCurdy and Candler be the one to provide answers as far as how they came up with this reinstatement figure?
No.
So if Ms. Zong had questions, you'd send her to PNC to get answers there, right?
Correct.
And as your role is, I guess, in your role as foreclosure counsel or attorneys for PNC, you don't actually double check these numbers or do any in-house analysis, do you?
We rely on the numbers provided to us by the servicer.
Understood. And you also rely on the addresses provided to you by the servicer. Is that a fair characterization?
Yes.
Under the foreclosure statute, are there significance as far as timing when things need to be mailed out within certain time periods or things like that?
There's a 30-day requirement in the foreclosure statute that requires us to send that notice at least 30 days prior to the anticipated sale date.
So timing, the dates can be important.
Yes, they are. Sure.
Let's pull up Exhibit 131, the Walls affidavit.
Should you want to move it, this should have this one, this one's not in. It's okay with me.
I don't need to. And you mentioned that Walls was your, I guess, just like you work for PNC or your PNC's agent, Walls works for you or provides mailing for your law firm.
Walls was a vendor of McCurdy and Candler at the time in question.
So they acted for McCurdy and Candler at the time in question.
I suppose that's fair, yeah.
And I want to scroll down a little further. Let's go down another paragraph. Let's stop right there. So let's just highlight paragraph 3 for a second. The first line. So, sure. So if we look at paragraph 3, first line specifies that on or about January 21st, 2012, Walls received direction to mail a foreclosure notice to plaintiff Fei Zong dated January 12th, 2012. Excuse me, January 20th. So on January 21st, Walls received direction that they need to mail a letter backdated to January 20th. Would you concur that's a fair characterization of what's said here?
I don't know that I'd agree with a backdated characterization. The letter was dated January 20th. And the next day it appears that we instructed Walls to begin mailing that notice out. Yes.
So you sent them instructions after the letter had already been dated. Is that a fair thing to say?
That's what the Senate says, is that the next day Walls was sent the notice to send out by various mailings.
I want to turn to JX 101. And I know you just briefly discussed this, but I just want to highlight the fact that according to this document, it says that there was let's say, set over and conveys without recourse onto Wells Fargo Bank NA GSR 2004-12. Is that a fair characterization of what this document purports to do?
Yes.
And let's scroll back down to the bottom. And this was done on behalf of PNC Bank. Is that correct? Or PNC Bank executed this document, I should say.
As far as I can tell, yes.
When these foreclosures were performed, were they performed on behalf of PNC, or were they being performed on behalf of Wells Fargo Bank?
You'll have to explain that a little bit more.
Sure. So let's go back to one of your previous letters where you actually sent that foreclosure notice. Let's pull up sorry, I actually lost the letter. Yes. And so in this document, let's just scroll down a little bit. It mentions that the creditor is Wells Fargo Bank.
Yes.
It mentions the servicer is PNC Mortgage. And let's scroll down to the bottom of that letter. And then it also mentions that basically it's your law firm acting on behalf of Wells Fargo and PNC. Is that a...
Your Honor, that's not what the document says.
Well, let me rephrase that. It's signed in the bottom. Could you tell me how it's signed?
It says McCurdy and Candler LLC, attorneys for Wells Fargo Bank NA GSR 2004-12, and PNC Mortgage, a division of PNC Bank National Association.
Thank you. Are you aware that the borrower could change their address with the loan servicer in order to change where that foreclosure notice is sent?
Am I aware that they could do that?
Yes.
I suppose. I'm not really familiar with how that happens, but sure.
I understand. Let's pull up 4414-162.2. And this is the statute we were just talking about a moment ago. So just to parse it down, and we'll highlight the important thing in a moment.
Okay.
But it mentions the first line that the notice of the proceedings, shall be provided. Excuse me, I'll read it verbatim. Notice of the initiation of proceedings to exercise the power of sale in a mortgage, security deed, or other lien contract shall be given to the debtor by the secured creditor no later than 30 days before the date of the proposed foreclosure. And then the next line, would you say it's a fair characterization that there has to be such information that includes, and let me just rephrase because that was a horrible characterization, and so my apologies. Like opposing counsel said, it's been a long week. Such notice shall be in writing, address and telephone number of the individual or entity who shall have the full authority to negotiate, amend, and modify all terms of the mortgage with the debtor, and shall be sent by, and this is where I want to start highlighting it, and shall be sent by registered or certified or statutory overnight delivery,
Yes.
return receipt requested to the property address, and perhaps the most important phrase here, or to such other address as the debtor may designate by written notice to the secured creditor. So if a debtor sends a notice to the secured creditor or its agent saying, I'm going to update my address in writing, before you weren't exactly sure if that was the case, but appears by the statute can be done.
Yes.
And not only that, but this statute specifically states that such notice shall be in writing, and it shall do certain things. It shall include the name, shall include the address, shall have full authority to negotiate. But most importantly, it states that it shall be sent to the property address or to such other address as the debtor may designate by written notice. Would you agree with that characterization?
I would agree that's what the statute says, yes.
I'd like to pull up JX 98. And I want to scroll down a little bit so we can see the two addresses that this notice was mailed off to. And so looking at those requirements under statute, the one that was most important is that the notice has to be sent via certified mail or statutory overnight delivery. Can we agree on that?
Yes.
And so these are apparently two certified mail receipts mailed to two different addresses for Ms. Song. Is that a fair characterization?
Yes.
And again, these are just the addresses that PNC provided you. It's not something you did independent research with or looked into yourself, is it?
That's my understanding. These were provided by PNC.
And is it your understanding that these are the only two addresses that you sent notice to Ms. Song at?
That's my understanding, yes.
All right. I have no further questions for you, sir. Thank you.
Okay,
Redirect.
thank you.
Your Honor, I'd just like to move the admission of JX 111.
Right, has everyone got a chance to take a look at that?
No objection, Your Honor.
It's the document that I didn't use it, but Mr. Hadary did and showed the notes to Mr. Olson. So since the jury's
email?
seen it, I'd just like it to be
Okay.
in the record.
All right, Jake's 111. just for the record, any objection on behalf of the planning?
I haven't been admitting a number of records because I don't think it matters for the proceeding. And so I do think it's improper for opposing counsel to try to admit my records. If he wants to show them and have them admitted, he can, but my case is relatively simple and I'm trying to keep my exhibits as relatively simple.
All right. Not hearing a valid objection, it's admitted. And any further redirect on behalf
No
of
further
PNC?
questions from PNC, Your Honor.
All right, any additional redirect or cross from Wells Fargo?
Yes, Your Honor. All right, so Mr. Olson, are you aware of whether Wells Fargo Bank NA GSR 2004-12, whether that's an actual legal entity?
I have no knowledge of that.
And you've never researched or looked into whether that an entity by that name exists?
No.
And I think as you testified, McCurdy and Candler just accepted the info that PNC provided.
Yes, that's correct.
No further questions. Thank you.
All right, Ms. Tobin, can this witness be excused?
PNC rests, Your Honor.
Okay, and he can step down. Thank you.
Okay.
Thank you, sir.
Thank you.
All right, Mr. Howard, any evidence to present on behalf of Wells Fargo?
No evidence, Your Honor.
All right, any reason, Mr. Hidary, that we can't proceed to the charge conference?
We're not going to do a rebuttal. Guess we can't, Your Honor.
All right, so members of the jury, it's an awkward time of the day. I'm afraid I'm not going to be able to land the plane today like I promised you yesterday. And the only thing I can offer you to make up for that is lunch tomorrow. So I'll be ordering pizza. But there's a decision of whether we've got to now do some things on our own. We have to confer about what law we think applies to this case and what we should charge you on. And that process takes at least 30 minutes to an hour, which could potentially still leave us an hour to start closings. Closings can be, each side is allotted 2 hours. They don't have to use it all, but they could. So basically, I'm going to let you go back and you can make your first decision as a jury, whether you want to call it a day or whether you still want to maybe start closings today while we work for probably, again, about 45 minutes to an hour here on what we need to do. So with that, if there are any other questions, I'll wait for your direction from Deputy Scott.
All right, so very.
All right, Deputy Scott, whenever you think they have an answer for you, if you could just have them commit that to writing and I'll share that with the parties. All right, I believe this might be the best time we could turn it over if the defendants are ready to present the motions that they had at the close of the plaintiff's case.
Your Honor, I'd like to also present a motion.
Oh, okay. Well, they'd go first, I think, right? Theoretically, it was we waived
I
it.
have no problem with that.
If you do need a minute, we can take a break. Yeah, we'll take 5. All right, we'll be back.
I can look. I mean, I've got it up on my computer. Also, 3 separate sets. Yeah. Oh, good. Gotcha. Good. Math.
I wanted to say it's not finished. It's got tomorrow.
Yeah, and-
Prize.
Yeah, and you could also let them know that Peter trust the sign with not only each other, Peter, that report.
Extension law saying
Oh.
it went well, defer to the others.
Oh, okay. Okay,
So
yeah.
it's still going on these.
Yeah. That should be fine.
Yeah, that's probably it.
Is that? Oh, yeah. No problem. No, no. Go. Okay. Go. Okay.
So gentlemen, please remember, it is a long week. Fingers and muscles, I'm exhausted. Please don't speed up.
Yes, ma'am.
Take a deep breath. I'm pretty sure this might continue on. You're gonna need these transcripts and you want them correct.
Has today been better than yesterday?
Yes.
Good. Good.
Learning.
Minus the loss, the fact that I lost 50% of my audio, but I think I'm gonna back up. So. But yes, definitely. a lot better.
What come on?
All good. We ready to go back on the record? Yeah.
Here you come in.
Okay. Snuck up on me. All right, let's go back on the record. I'll just say this first thing. First, note back is jury wants to stay, but has a hard out at 5 p.m. So if anyone wants to see that note, there it is. And let's see how we go. So, Mr. Tobin, floor is yours.
Thank you, Your Honor. At this point, I'd like to present a motion for directed verdict on behalf of my client, defendant PNC Bank NA. I have a few issues I'd like to present for the court's consideration, and I'll try to do it efficiently but slowly enough to not torture the court reporter. First, on plaintiff asserts a claim for wrongful foreclosure against PNC. Wrongful foreclosure under Georgia law is in effect a negligence cause of action. So the familiar elements of negligence are what plaintiff needs to prove by a preponderance of the evidence. First, that there's a legal duty that's owed by the defendant to the plaintiff. Second, that there's a breach of that duty. Third, that there is proximate cause. And four, that there are resulting damages. So the notice statute that we were just going over with Mr. Olson is the source of the duty that plaintiff must prove a breach of in order to establish wrongful foreclosure. One of the reasons for that is that Georgia law is a non-judicial state. So contract law governs the rights of secured parties to enforce security deeds through a foreclosure sale. And section 44-14-162.2A prescribes the notice requirements. And the statute makes very clear that there is no delivery. There's a delivery requirement. There's not a receipt requirement. So PNC was obligated to deliver notice by certified mail to the plaintiff. And the evidence that we've adduced, I think, proves that. I understand, well, I think I can predict the court's conclusion on this. Ms. Zong did testify very close to the end of plaintiff's case about a coupon sheet that she filled out and changed the address. So there is sort of a factual issue that I suppose a jury will need to decide on that particular point. But there are other aspects of the wrongful foreclosure tort that we think are susceptible to decision on directed verdict. One of those is intentional or emotional distress damages. We heard a great deal of testimony on the first day of the trial about the emotional distress that Ms. Zong experienced. And there are elements of this part of the tort that perhaps that testimony satisfied, namely that the harm that she experienced was severe and that there was causation. I don't think those are particularly close questions, but I do think they're jury questions. However, plaintiff also has to prove that the defendant engaged in conduct that was intentional or reckless and that such conduct was extreme and outrageous. So emotional distress is not an ordinary component of negligence recovery, and that applies in the wrongful foreclosure context. Rather, like many of the sources of recovery that plaintiff is pressing in this case, there's a heightened proof requirement that plaintiff must establish. I'm sure we'll be hearing from Mr. Hidari on this, but the evidence at worst of PNC's conduct as the servicer of plaintiff's mortgage loan was that there were some indications of negligence. But that's not enough to recover emotional distress damages. There's got to be something much worse. It's got to be extreme and outrageous conduct that's intentionally or recklessly undertaken and that results in emotional distress on the part of the plaintiff. The first two elements there are unsupported by any evidence that we've heard at this lengthy trial. So we would move for directed verdict on the request for emotional distress damages on the wrongful foreclosure tort. Similarly, there's a second category of damages that the Court of Appeals recognized plaintiff could pursue at trial here. That is damages to credit. And we've heard nothing that would substantiate damage to credit. We heard some general testimony from Ms. Zong and from her son that credit's important. But in terms of actually establishing a record of evidence loan applications denied, credit scores going down, anything like that. Plaintiff chose not to produce anything. So the two categories of damages that the Court of Appeals said plaintiff can seek stand here unproven. So for that reason, because wrongful foreclosure is a negligent tort and the plaintiff's obligated to prove each element of the tort by a preponderance, we move for directed verdict on the wrongful foreclosure claim against PNC. Plaintiff also seeks punitive damages on the wrongful foreclosure claim against PNC. This is another claim of plaintiffs that is subject to a heightened evidentiary requirement. Here, plaintiff doesn't have to prove her entitlement to relief by a preponderance of the evidence, but rather by clear and convincing evidence. And that clear and convincing evidence has to show that PNC's actions showed willful misconduct, malice, fraud, wantonness, oppression, or that entire want of care which would raise the presumption of conscious indifference to consequences. That is not what this case was. There were complaints. They could have explained it better. They didn't explain very well. Somebody was kind of rude. You know, I sent in an address, but the address that wound up getting used just said Alpharetta, Georgia, without having the street address. This is not malice, fraud, wantonness, willfulness. There's no record upon which plaintiff can recover punitive damages against PNC from a reasonable jury. Georgia law recognizes negligence is not enough, so the entire claim should be stricken. And in any event, Georgia law also establishes a cap of $250,000, which can only be exceeded if the defendant is proven to have had the specific intent to cause harm by clear and convincing evidence. There is no evidence adduced on this record, even close to anybody from PNC having a specific intent to harm Fay Zong. We didn't hear anything like that, so clearly that question should not be permitted to be considered by the jury. As we have heard at great length, the plaintiff is looking for attorney's fees also. This is yet another claim that's subject to a heightened evidentiary requirement before plaintiff can recover. Statute is OCGA 13-6-11. It's entitled Recovery of Expenses of Litigation Generally. And it says the expenses of litigation generally shall not be allowed as a part of the damages. In other words, the American rule applies in Georgia. But where the plaintiff has specifically pleaded and has made prayer therefore, and where the defendant has acted in bad faith, has been stubbornly litigious, or has caused the plaintiff unnecessary trouble and expense, the jury may allow them. And Wells Fargo's counsel has done a very nice job of briefing this requirement. There needs to be a showing that before my client can be subject to this possible category of recovery, that it acted in bad faith in the underlying transaction. And Georgia law provides a definition of bad faith. It sounds a lot like what I've been talking about before relative to emotional distress recovery and punitive damage recovery. Marta V. Mitchell, the defendant's conduct during the underlying transaction was characterized by a dishonest purpose or conscious wrongdoing. So plaintiff can get to the jury on attorney's fees if PNC engaged in a conscious wrongdoing or for a dishonest purpose. There needs to be evidence of this. There isn't any. So the attorney, and the other phrase, there has to be an interested or sinister motive. You know, some sort of old-fashioned diction applies a dishonest purpose or some moral obliquity, applies conscious doing of wrong, means breach of known duty through some motive of interest or ill will. Again, there's only some evidence of negligence. There isn't evidence of anything like that. So the fees claim should not be permitted. And there's one final claim. Thank you very much to the Court of Appeals, who came up with the idea that Mr. Adary had not, which is a promissory estoppel claim may be available here. Contract claim is not available, so, but promissory estoppel may be. So let's review, go back to first year of law school and remember what this is. Defendant has to have made a promise. It should reasonably have expected when it made that promise that the plaintiff would rely. The plaintiff has to have reasonably relied on the promise, and injustice can only be avoided by enforcing the promise. Plaintiff's claim of promissory estoppel fails on each one of those, but most obviously on the first one. Made a promise. I take Ms. Zong, I imagine, would say if she were to get up and oppose my motion that the conversation that she had in January of 2011 about redoing the escrow analysis would satisfy this requirement. But it doesn't, because we've seen all of the evidence that Mr. Bevins talked about from the call notes and the like that indicate that she was specifically told, specifically advised, no, we can't do that. We can't push things back. So there's no way the PNC could reasonably have expected Fei Zong to expect this promise to be performed, nor can she have reasonably relied upon it because she was specifically told by PNC that no, we're not going to do that. We can't do that. And every time she tried to make a payment from immediately after it, the payments were sent back to her. So estoppel just doesn't make any sense here in my view. And the final element of promissory estoppel is that injustice can be avoided only by enforcing the promise. I'm not sure how you enforce this promise. I mean, this 700 Latour Drive, I mean, we heard what Ms. Zong is looking for. She wants her home back. That's not happening. I mean, there was a bona fide purchaser for value 12 years ago. There isn't any legal mechanism by which the court can somehow enforce this promise by giving her back her home. So for all those reasons, we think promissory estoppel fails as well, and we request directed verdict on that claim too. Thank you.
Thank you, Mr. Tobin. I'll take your motion under advisement. Mr. Howard.
Thank you, Your Honor. I will be making a motion for directed verdict on behalf of my client, Wells Fargo, as well. I'm not sure I'll present it as eloquently or as slow as Mr. Tobin presented his, and there will be some similarities, certainly. I'm going to cover the issues in a little different order. I'm going to start with punitive damages. Certainly, Your Honor, under the evidence as adduced throughout the course of this trial, Wells Fargo should be entitled to a directed verdict on punitive damages. And I'll remind Your Honor that you expressly ruled prior to the trial that we have not admitted liability for those. So we're allowed to contest those. Now, as Mr. Tobin said, plaintiff bears the burden of proving punitive damages by clear and convincing evidence, which is a higher standard, obviously, than a preponderance of the evidence. And he must show that Wells Fargo's actions showed willful misconduct, malice, fraud, wantonness, oppression, or an entire want of care, which would raise the presumption of a conscious indifference to the consequences. Now, Wells Fargo is in default. We are not contesting that at this stage. We've attempted to repeatedly. But what we've admitted to as a result of the default is that Wells Fargo committed the tort of wrongful foreclosure. But Georgia law is abundantly clear that that is not enough for punitive damages and that plaintiff must establish something significantly more than the mere commission of a tort. The case I have for that, Your Honor, Lindsay versus Clinch City Glass, 312 Georgia Appeals 534. And the appellate courts, Your Honor, have held that if a plaintiff fails to meet that high burden, it's appropriate for the trial court to direct a verdict in favor of a defendant. And the case I have for that is Puckette, Puckette versus John Bailey Pontiac, 311 Georgia Appeals 138. Now turning to the evidence, Your Honor, what has plaintiff proven that Wells Fargo did in this case? Beyond the admissions as a result of the default that we committed a wrongful foreclosure, I would tender that he has proven absolutely nothing. Plaintiff's case is closed. It remains undisputed as a factual matter that Wells Fargo was not the servicer, made no decisions with regard to Ms. Zong's loan, was not responsible for accepting and applying payments, had no communications with her, and neither hired foreclosure counsel nor was responsible for directing foreclosure counsel to send notices to Ms. Zong. that's the evidence we have, Your Honor. There is the name of an entity that it appears is a fictitious in the documents. The evidence is consistent that that was a typo made by PNC, that was information provided by PNC in every circumstance. I mean, that was not something that Wells Fargo Bank NA, which is different than the fictitious entity we're talking about, that was something that they authorized. Now, I'd like to point, Your Honor, to a case, Vizio Financial Services, Inc., 360 Georgia Appeals 691. It's a 2021 case, and Your Honor, it's instructive because the facts of that case are quite similar to the case at bar. In that case, in Poverty Destroyed Forever, which is a great name, by the way. In that case, the Court of Appeals affirmed a trial court's decision denying punitive damages in a case where a foreclosing lender sent notices to the wrong address. And as a result, the foreclosure went forward and the borrower filed a suit and alleged wrongful foreclosure. In that case is very similar to this one, but for my client's perspective, we're even more innocent than the defendant in that case. That case, I think, frankly, would protect PNC, but we're a step removed from that, Your Honor. So I think the evidence is undisputed that since we took no action with regard to the loan or the foreclosure, I think the evidence is disputed that Wells Fargo wasn't even aware of the foreclosure until they were sued. That plaintiff has just fallen far short of this incredibly high bar for punitive damages, and a directed verdict should enter on that issue in Wells Fargo's favor. And again, the default has no effect on that, Your Honor. We've not waived the ability to make that argument. Second, I'm going to make a similar argument to Mr. Tobin with regard to the different buckets of damages that plaintiff is apparently seeking. Now, we've admitted, as I've said, as a result of the default, Wells Fargo has admitted wrongful foreclosure, but plaintiff still bears the burden of proving damages that she suffered as a result. And the evidence on damages in this case is woefully deficient, Your Honor. We believe it's sufficiently deficient that Wells Fargo is entitled to a directed verdict on all of plaintiff's damages claims except for her claim for nominal damages, which we acknowledge goes to the jury regardless. And there are a number of cases, Your Honor, that say if they prove nothing else, they haven't proved anything else. But in that situation, they still get to go to the jury on nominal damages. So looking at the two buckets I referred to, the first is any financial injury or credit injury to Ms. Zong. And the issue here, as Mr. Tobin put it, is that plaintiff has presented no evidence on this issue whatsoever. It's not a close call. She never got to it. She never presented it.
So you'd incorporate all the arguments made by Mr.
Yes,
Tobin
Your
on
Honor,
this?
and I'll speed up. I'd like to cite a couple cases. I appreciate it. Cato Law Group versus Benavidez, 362 Georgia Appeals 850. And particularly a case, Reed versus Benedict, 200 Georgia Appeals 4. It's a 1991 decision. And the Court of Appeals in that case affirmed a trial court's decision to grant a directed verdict on a damages claim, even where even where that defendant was in default, because the plaintiff, like the plaintiff here, failed to present evidence permitting the jury to calculate damages to a reasonable degree of certainty. So under that decision, Your Honor, the default does not prevent us from making this argument. My last point on that issue, Your Honor, is these damages are entirely speculative based on the lack of evidence. The second bucket, Your Honor, is Ms. Zong's emotional damages. I would incorporate the arguments made by Mr. Tobin very ably on that. She has not alleged any conduct that was sufficient to carry the high burden for emotional damages in a wrongful foreclosure case. McCarter versus Bankers Trust, 247 Georgia Appeals 129. That's a 2000 case. And she has to show the exact conduct, the type of conduct that Mr. Tobin referenced. It has to be extreme and outrageous, and there's no evidence of any of that. So we've admitted the wrongful foreclosure, Your Honor, but we've not admitted any conduct meeting that high standard, and plaintiff hasn't presented any evidence on that high standard. And citing back to that same Reed versus Benedict case, that authorizes Your Honor to enter a directed verdict. Thirdly, Your Honor, and I'll be very quick on this because Your Honor has already ruled just for purposes of presenting a record on appeal, We believe that we're entitled to a directed verdict on attorney's fees. We're at a different posture than the prior order, Your Honor. Plaintiff has presented all of her evidence, and she fails to meet the high standard for attorney's fees that Mr. Tobin explained. And I think, Your Honor, as I've said before, the allegations about attorney's fees were legal allegations. They weren't factual. They were legal conclusions, not factual allegations, and we should not have admitted them by default. So where does that leave us, Your Honor? I think it leaves us in a position where plaintiff should be entitled to get to the jury, but only on nominal damages, which we don't dispute that she's entitled to get to the jury on those. Thank you.
All right. Thank you, Mr. Howard. I'll also take that under advisement. All right, Mr. Haydari, you said you had a motion as well.
Yes, and the only purpose of this motion is for the record, Your Honor, not because I intend the court to actually rule on it, but it would be a motion for directed verdict specifically on the wrongful foreclosure claim. And well aware that the issues of damages and causation would be one for the finder of fact. But the reason why I'm making this motion is because of the issue of breach. At this point in time, if we look at Zong 2 in the 2018 opinion, the Court of Appeals, and I think it's worth actually looking at, Your Honor, because it's on point on this one issue, which is the one defense that PNC has asserted in terms of my inability to change the address was rejected. And so if we look at, I guess this is on the, let me see what division this is. This is Division D. PNC argues that this designation of a new address was not effective because Zong's attorney did not have the authority to make it. And then the Court of Appeals goes through and explicitly addresses that Zong's attorney was her agent with the authority to act on her behalf for the purpose for which he was retained. And it addresses PNC's argument explicitly, stating specifically that PNC asserts that Zong submitted an authorization form which gave PNC notice that she had restricted her attorney's authority in a manner that would prohibit the attorney from designating a different address. In the authorization form, however, Zong merely asked PNC to release information about her loan to her attorney. The form does not speak to any limits on the authority of Zong's attorney to act on her behalf in communicating with PNC. This, or the authorization form, is applicable to any third party to whom a customer might want loan information to be released. And perhaps the most important line is it cannot be construed as an express restriction on an attorney's authority. And so the one argument they have made in this matter, as far as why my designation to send any and all correspondence to me was inapplicable, and I made this very clear with Mr. Bevins when I cross-examined him, was the general release form, which the Court of Appeals has already established, and which is now law of the case, that it cannot be construed as an express restriction on my authority. And so for that reason alone, we would move for a directed verdict just for purposes of preserving the record for appellate issues that might arise.
All right. I'm curious, Mr. Tobin, if you want to respond to that point. I mean, I think the Court of Appeals said that it raises a triable issue. I don't know if it was so conclusive as to say that the letter, I mean, I think they made it sound like that's a point for the jury to figure out whether that letter went so far as to supplant the address.
That's my understanding, Your Honor. I mean, we haven't seen any evidence of a letter from Mr. Haidari saying, here's the mailing address that changes for Ms. Zong. You know, all he said was generally send future correspondence to me, and then PNC didn't. In any event, that's what happened. I mean, the Court of Appeals reversed summary judgment and said, no, this could be a fact issue that needs to be resolved. And so it seems to me that if the wrongful foreclosure claim gets to the jury will have to decide that as a factual matter.
Okay. All right. Well, thank you, Mr. Haidari. I'll take that under advisement as well. So the one thing I want to clear up before we would go into the charge conference is this issue of attorney's fees. As I'd mentioned before, I think I was under the impression that in part that Mr. Hidari's testimony may not be necessary if we don't get to a part two. But based on Wells Fargo's default as we currently have interpreted it, it seems like a part two may be inevitable. And so, but Wells Fargo is still trying to see if there could be a stipulation or agreement on this front, in which case then I would say, if that's the case and we're not dealing with the attorney testifying issue, I would put him back in part one, so it'd all be part of the same verdict form. So I think we need to finally get back to this. And as I interpreted it, when we kind of went back and forth on this, is we were trying to see, we recognized the language in Devereaux that, you know, the attorney's fees have to be accompanied by reasonableness and be justified. I don't think there's any dispute about stipulating to that. It's more so the amount. And what I took it originally was Mr. Hidari would be asking for the contingent fee amount, but wasn't willing to box himself in there or not. I'm not sure. I'm going to let you clear that up for me here.
I think that's a fair characterization, Your Honor. My intention is to ask for a contingency amount, but just as you mentioned, I'm not willing to box myself in there.
Meaning that you think they should be able to award you above the contingency fee amount?
They should be able to award a reasonable, the reasonable value for my services. And that could be the contingency fee amount. If they find that it's my reasonable value of my services is less than the contingency fee percentage, then they could award my, you know, whatever my reasonable fees might be.
Which you believe could be more than a contingency fee.
It could be depending on what they ultimately award.
Right. So yes, could be more. Okay. Any reactions to that from either side?
One thing, Your Honor, I'd like to see a proffer of the evidence that Mr. Hidari intends to present on his actual attorney's fees, if he's hoping the jury is going to award more than the contingency fee. The exhibit that we received like the afternoon before trial was a summary statement. Did not appear to be made at the time that the charges were incurred. There's been no testimony that he was invoicing her monthly and writing all of his time down. In fact, it appeared to me that some of the entries in the statement were sort of mass quantities of time. So I'm curious as to how Mr. Hidari is going to prove that, if that's really what he's trying to prove.
Well, and is that also a viable ask? Can someone ask or say, I'm currently working under contingency fee, but you can go anywhere on the spectrum and award whatever you want? I mean, I just haven't researched this issue. I don't know if you have.
To that, Your Honor, it certainly doesn't seem fair. It seems like you're not getting a contingency fee. You're kind of getting two bites at the apple. But I haven't researched that specific question, so
Okay, maybe some more homework for tonight. All right, so let's dive into the charge conference. And before we do that, theoretically, if we can knock this out by 4, I think we could get the first hour of somebody's closing today. And so was plaintiff intending to begin the closings?
I was intending to have both opening and concluding remarks.
Okay, all right. And
I just didn't hear, what'd you say?
he wants to go first.
First and last.
Do you have any other visual media that we'd need to prepare for? Would you be showing exhibits or something like that? That's something you can handle.
I think we're going to get to my concluding remarks as well.
Oh, no. Well, I wouldn't imagine that at all.
Dead name.
I don't, well, actually, do you have a prediction of how long your first opening or closing is? Sorry.
No, I actually don't have a prediction, Your Honor. So we will not need the screen.
Okay. Well, if it ends up being a 10-minute one, then I might still want to use a little bit of defense time. They wanted to be here all day and make the most of it, so I want to respect their wishes there. I'm going to have the clocks up there, and I'll be keeping track of everybody.
Yeah, I mean, my hope certainly was that we'd close tomorrow, but jury's in charge, so.
Yeah. All right. So let's get into it. I believe everyone should have been emailed yesterday, kind of our consolidated all the requests. So this is going to be our working copy as we go through it. And at any point, if we saw that a pattern may be applied, we plugged that in so we could compare the two. And it does look like, just by the nature of the civil charges, there's going to have to be a lot of kind of nipping and tucking here. So just starting on page 1. And again, this is more, the way I've done these before is more of an informal thing where if you have a point, I'm going to go through it just saying my observations. And when you have a point, feel free to raise it. On the first page, I was going to shorten that. I didn't plan. I see it's within the discretion of the court completely, whether to send the pleadings out. And so my plan was not to do that. And so I would just have the first paragraph as part of this pattern charge. And I would amend the last sentence there in which she contends. And I would model that along the lines of the opening, essentially just reference the two claims, wrongful foreclosure and promissory estoppel. So something to the effect of in which she contends PNC and Wells Fargo are liable and owe damages on the claims of wrongful foreclosure and promissory estoppel, and stop. And that would just be the intro paragraph.
Your Honor, this is kind of on the side of this, this charge, but we would request that the pleadings be sent to the jury.
All right, noted.
So PNC certainly would oppose that, for the reasons we talked about in the one bench conference that we had.
All right. I think that because several of these claims did not survive, I think it would create more confusion. And so I'll note the objection and overrule it. All right, moving on to the second page, we've got preponderance of the evidence. I want to put it out there. This should be the most recent one. I know that just got changed, and I want to make sure everyone signs off and they think this is the right preponderance of the evidence charge. It should be. And I'll just amend it by striking the party bringing any claim. I'll just say the plaintiff because we don't have any counterclaims here. Amend it to her claims. Again, strike the other reference to the parties in the second paragraph. Party making the claim in the third paragraph. I'll include the bracket about where more than one claim is involved. And then finally at the end, it would be striking the parties. And then we would just include the bracket for defendant, not counter-defendant or cross-claim. Not seeing anything from the parties on that. We'll move to 3. I don't think we actually had any formal stipulations at this point. Maybe that'll change tomorrow if we hear some additional argument or research on attorney's fees. But for now, as well, if we're going into closings, I guess that's not going to change. So we'll just move forward. And I would say I would strike the parenthetical in the second paragraph. We have some additional parentheticals in the final paragraph. The first two seem fairly redundant. I would just strike the such as by personally observing or otherwise witnessing. I think an eyewitness encapsulates that. And then I would keep in the other remaining parentheticals and brackets. Have that full charge. Moving on to page 4.
Your Honor,
Yes, sir.
I do think it'd be nice to keep I know it's redundant, but such as by personally observing or otherwise witnessing the fact, I would request.
Okay. I'll leave it in and I'll just add an or between those two parentheticals.
Your Honor.
All right, page 4, direct circumstantial. Looks like we've just got 2 options there, unless there's a strong preference.
Not sure why we need 2 definitions of direct and circumstantial. We had one in 3.
Okay, so is there a proposal on the floor is just to strike page 4 entirely? Since the types of evidence are kind of already covered, and it's really not, I think, the core of this case of whether something's direct or circumstantial.
I would request to keep circumstantial evidence, Your Honor.
Well, which definition? I guess the point is the circumstantial evidence has kind of already been defined on page 3 in evidence generally.
Preference is that first paragraph on page 4.
Okay. All right. So let's do this then. On page 3, we have the paragraph that begins with "in considering." Instead of using that paragraph, we've got the first two on page 4. That covers what direct and circumstantial is, and I actually like those definitions a little better. And then we wouldn't need the bracket, the following, or everything that follows. So if just to summarize again, we would start on page 3. Evidence may be direct or circumstantial or both. And then we would turn and say direct evidence is evidence that immediately points. Circumstantial is evidence that only tends to establish a fact. And then we end there. Any objections? Or seeing none. Moving to page 5, we've got a plaintiff's request about an affirmative defense. I don't think there was any affirmative defenses here, so I would strike 5. All right, turn into 6. We've got this is the rebuttable presumption. We already covered that, so 6 would be struck. Page 7. This is talking about admissions and pleadings. It's not a pattern charge. And to the extent it's relevant, I think I already covered it by instructing them about that admission. So I wouldn't be inclined to give 7. Is there anything else you want to add in defense of it?
My recollection is we're going to get to the implications of the default later as well. So I'm striking that.
All right. That is struck without objection. We get to judicial notice. Does anyone think I actually took judicial notice of anything? There was an in judicio admission, but I don't know if that would be considered judicial notice. So without objection, we'll strike page 8. Limiting instruction, I did give one of those, and it is on point. So sometimes evidence is admitted for a limited purpose or against some parties and not others. Such evidence may be considered by the jury for the sole issue or purpose against that party for which the evidence is limited and not for any other purpose. All right, moving on. Page 10, expert witnesses. We've got alternatives here, the 11th Circuit versus, I guess, our Georgia version. Any preference from the plaintiff?
Third paragraph again, Your Honor. 1 second, sir.
I'm sorry?
I would prefer Georgia's charge.
All right, the first 2 paragraphs. Any feelings from the defense?
I think that works better myself.
Yeah, I agree.
Okay, take that, 11th Circuit. Moving on to page 11. We've got fair market value. I don't think this was requested, but just because we saw it was in the pattern, we took it over to see if it was worth consideration. Do any of the parties think that we should have either of these pattern charges on fair market value on page 11? Let me start with the plaintiff.
First one,
I'm sorry.
I'm okay with the first one, and I'm okay with the second one as well.
Well, and it's not necessarily that I think it should come in. It was just more if we think it actually adds value and if there's slight evidence making it a relevant consideration. So hearing there's no objection to include it, let me go over. I'm from the plaintiff. I'm getting here. Let me turn over to the defense, Mr. Tobin.
Yeah. PNC's view is that we should have a very different sort of instruction, one that makes clear to the jury that they're not permitted to consider fair market value because the court ruled on lost equity damages that they are not available. And there was some testimony that came in over defendant's objections from Mr. Himes about the value of the property. So we think the jury needs to be explicitly instructed that lost equity damages may not be awarded. And we could, of course, come up with some drafting rules.
Your Honor, we didn't even talk about equity.
I mean, if you use that term, you're going to get a bunch of blank stares. I mean, they don't even know what that means because it hasn't even come up. I haven't heard an argument saying, look how much the house has increased in value. So
Well, we made it before in our motion in limine, and testimony did come in on value, which we objected to. So we're concerned, and this was the concern we articulated, that the jury is going to need some basis to come up with a number if they're allowed to award damages. And those are really the only numbers that were provided. Mr. Rhimes talking about value. So, and that's not a valid basis for damages in this case. So I think the Yes.
Okay.
On the record here.
Yeah.
So I think that I take your point. Yeah, all right.
I'd just like to be heard, Your Honor.
Mhm.
My position is this is irrelevant and should come out entirely. I think Mr. Imes testified to some generic property values increase slowly over time. He was not retained to be an expert to testify about the fair market value of the property specifically. I think this, if included, would be suggestive to the jurors.
Yeah. I think that's where I'm landing as well. He did reference maybe the 5 comparables, but I don't think he was ever said this is exactly what the house is worth now, if I recall correctly.
But he did provide that range. Well.
Right.
Neighborhood or between.
And we can talk about that when we get to the damages portion, but in terms, he may have provided a range, but to hone in and start focusing on fair market value. Again, I think these charges, as you can see from it, are taken more from other types of cases where that's more at issue. So,
Your Honor, I have no objection to striking these.
okay, well then I should have started there. We'll strike page 11. Page 12 is credibility of the witnesses. It seems to be the pattern charge. All of it appears applicable without any brackets or parentheticals, so I'll give 12. Page 13, witness impeached. I would just give the second sentence. It seems a little more succinct. Seeing no objections, I'll turn to page 14. We've got prior statements. I do believe we had a good reference to either documents or depositions and that sort of thing. So that would be at issue. I don't see anything to craft here, so I would give 14 in its entirety. Let me note here, I might have forgotten to mention this, is the intention is after we're done here, we're going to remove all the headings, scrunch them all down to about a 10-page document, and that'll go back with the jury.
Just a miscellaneous question. I don't know if, well, strike it, Your Honor.
This is a good time as any.
Well, I was just wondering if you were going to give the charges to the jurors in written format before you instruct them. I've had.
That's interesting. I've never thought about that. I usually just do one copy stocked on top of the exhibits, and that goes back with them. And when I'm reading it to them, they're just sitting there suffering. But I'm willing to entertain a new
Might be a
variety, so I'll let y'all discuss it. You can let me know in the morning. I'd be willing to print 12 copies if that's what you think. I'm a visual learner, so I actually would appreciate that as a juror. All right, page 15. Oh, did we already cover that?
Yeah,
Yes.
it seemed to be a repeat.
It's a duplicate. Okay, so we're going to strike 15. Page 16. This is now getting into, we've got a plaintiff's request to charge about default.
I have a case on point on that, Your Honor. It's Zong versus PNC Bank.
Partial objection to it.
Well, it does seem a bit overbroad in terms of, like we mentioned, Wells Fargo hasn't admitted liability for punitive damages or injuries flowing from that. I don't know if that would be the right place for it. Let me hold on 16 because I think this is also brought up elsewhere in the pattern charges. So let me see if we can plug this into a more appropriate spot. So we'll hold on 16. 17 is now we're getting back to the pattern charges of torts just generally. I mean, I would say we'd strike the parenthetical a tort case and just call it 1.
Your Honor.
But then we also have an alternative defendant's instruction here. So
I think that's a nice summary, so I think it'd be nice to include.
okay. Any concerns with the defendant's requested instruction on page 17?
Just in reading it now, I prefer the pattern, but let me look a little further, Your Honor.
All right, and this is where I think we would combine in plaintiff's requested charge on 16 then. So let's, using the defendant's requested instruction as a template. What is it in your requested charge one, Mr. Hadary, that you would want combined into page 17? Specifically, I'm kind of looking at that second sentence, the Wells Fargo default means.
I'm not sure what second sentence you're referring to, Your Honor.
In the defendant's requested instruction on page 17,
Oh, 17.
right in the middle of it, it starts talking about the Wells Fargo default.
Oh, I went to the prior page. My apologies. So the first issue I had with this case, or I mean, with this charge is, there's not just the claim for wrongful foreclosure. So we also have the claim for a promissory estoppel. And I'm not sure if we deal with that further, but I think that's one issue. And then to prevail on her claim against PNC, we do have to prove it by the preponderance of the evidence, but we don't have to prove that there was some negligence of PNC. I think that's an improper statement. I think it's an analogous standard to negligence, but I don't think it is negligence, which has a different meaning under the law.
I'm not sure I follow you there. I mean, the negligence is the same thing that's referenced right above it, the one you said you liked. Must prove by preponderance the negligence of the defendant.
Right, but if we're isolating this to wrongful foreclosure, then we're missing the promissory estoppel, which has made a promise and it broke it.
Well, that'll come up later if you see in the charges that first we do wrongful foreclosure, and then we're going to get to promissory estoppel. I think we could make it clear the first claim.
Oh,
So we could even say it, the first claim before you involves a claim for the tort of wrongful foreclosure. And at the outset, I would have said that she's bringing two claims.
so I'm okay with the first, I guess, sentence, Your Honor, and then it gets to the Wells Fargo default. And on that sentence, I would like the jury to be instructed, sort of like, are we doing a mishmash of this one plus the prior charge?
Well, I guess the idea is, what does this charge not include that you feel needs to be said and was said on page 16?
I'd like a sentence that says that Wells Fargo is in default, because I'm not sure the jurors might necessarily understand what the Wells Fargo default means, or that sentence. It just might not be cleared.
All right, so the proposal would be Wells Fargo is in default, comma, which means.
Yes.
All right.
Um,
Any other objections to defendant's requested instruction on 17? Seeing none from the defendants, then we'll go ahead and strike page 16. We'll give 17 as amended here. And again, the idea is you're going to have this consolidated one for everyone to review before, this evening.
Just in terms of spacing, I think it might make sense if we break off where we've satisfied those requirements just to Wells Fargo, and then push it down an extra line or an extra little small space, and then start, however, the assessment of liability as the PNC.
Okay, asking for an indent
Yes.
before, however. That's fine. Turning to page 18, we've now got the elements. This is from Zong on plaintiff's request to charge. And then I think this is also addressed through defendant's request on page 19. Okay, so we're getting a little duplicative here. I'd start off by saying on the defendant's request on page 19, I think that first paragraph would have already been covered by what we just talked about on page 17. Then the defendants list the elements.
And we do think that the instructions need to include some references to the statutes and some good summaries of them. So we think that these paragraphs are good, but statute requires and also quoted.
My preference, Your Honor, would be to actually put the statute as a separate charge so that the jurors can see what the statute says.
I think that's what they've essentially quoted verbatim here in their third paragraph on page 19 under this statute.
Duty under.
Maybe we'll throw in some quotation marks to make sure we're okay. So in the paragraph where it says under this statute, we're going to throw in quotation marks to actually make it clear what is the language of the statute. But otherwise, I think we've already got the elements covered on page 19. So I would strike page 18. I'd strike the first paragraph of page 19. We'd go right into the elements because we just talked about preponderance of the evidence. Then we've got the statute.
Your Honor, I would also like to strike in that paragraph, the last two sentences where the duty under the statute is satisfied once the foreclosing party mails in the notice, and whether the debtor actually receives the notice is immaterial. That is, the second line, I believe, is an accurate statement of the law. And the preceding line requires certain other things, like it must be mailed via statutory, overnight, certified mail. And so I don't want to, my preference would be to strike those last two lines and have those be argument.
Okay, those last two lines, those are not part of the statute.
Correct, the duty under the statute.
Sorry, which two lines are we referring to?
They're not part of the statute, Your Honor, but they are black letter Georgia law.
Right, so we would certainly object to the exclusion of those sentences, and we'd want that objection on the record, which I understand it now is. We think it belongs, as I say, it's black letter law, that's correct, so it makes sense to instruct the jury as to those important principles of Georgia law.
Okay, at a minimum, let's put a paragraph break there so it's away from the quotation of the statute. And I think that comes up again later. There's another request for this. And so let me hold on that one and come back to it. Okay, so where we've got that statute where it says not requested, that'll be combined with the preceding paragraph. We've then got at the bottom of page 19, the defendant's request continued, where we talk about proximate cause. Is there anything to note about this first paragraph about proximate cause on page 19?
I might be incorrect, but I thought there was proximate cause somewhere else in these charges.
Let's see if I can. There is. It's on page 22.
My preference would be to have one definition rather than two that might provide confusion.
I certainly agree with you. We're either gonna strike 22 or we're gonna strike this paragraph. So that's what I'm kind of soliciting input on.
I think 19 is more specifically geared to the claim at issue. So PNC thinks that's a better approach here.
I would prefer the pattern charge, Your Honor, on page 22.
Mr. Howard?
I would join, Yancy's position.
Other definition. The first definition includes that unbroken language, which is not present in the pattern charge, and I don't believe that's a proper statement of the law.
And there's another kind of aspect of the pattern charge which starts talking about, the combination with other causes that I don't think is expressed in that paragraph.
I agree, Your Honor.
Okay, so what I would think we would, and we'll establish this for the record, we would keep the first sentence where it's, if a plaintiff establishes a breach, she must further show defective notice was the proximate cause of the plaintiff's injury. After that sentence, I would put in the pattern charge on proximate cause. Strike the remainder of the proposed defense charge with the objection noted.
There is one other sub-issue, Your Honor, which is as we're talking about the improper notice, you know what, disregard my statement, Your Honor.
All right. So the last paragraph there is a kind of, again, a summary that plaintiff has to carry their burden onto all four
Got an objection on the record. So that means that the last sentence of the defendant's proposed instruction, plaintiff must establish by a preponderance of the evidence that she would have cured her default if statutorily sufficient notice was timely mailed prior to the foreclosure sale. We just want to make sure our objection is on the record that we believe that should be included to accurately state Georgia law. So we object to its exclusion.
If
All
I
right. I
respond-
think that's absolutely something you'll be able to argue all day at closing. I'm going to keep it closer to the pattern charge, but the objection is noted and it's on the record. The final paragraph, I think we may be repeating ourselves here, where we're talking about the four elements and the default status.
Your Honor, are you intending to keep the unbroken by other causes language? Or are we?
No, it was that entire paragraph is going to be substituted for the proximate cause.
Understood. Thank you.
And for the bracket, we would keep the bracket on the pattern charge as well,
Thank you.
but not the parenthetical.
Sorry, in 19, you're striking the last sentences of that. Are you striking that entire last paragraph? Just some.
No, we're not there yet. So the last paragraph that begins with to establish her claim. I was taking a look at that, seeing what we have or have not already covered that's in that paragraph. And I think we haven't included that four elements language. I find that helpful. And I think that's how our verdict form is likely to be laid out. So I would keep in that first sentence. We've already talked about the default status. So is there a position from the parties as to whether I keep in the remainder of that requested charge? That paragraph that begins with to establish your claim. Let me start with the plaintiff. I think I'm inclined to keep it in its entirety since it kind of just makes the default clear and what elements are at play.
I agree, Your Honor. It's not bad.
Okay.
The whole paragraph in.
Keep that whole second paragraph that follows the wrongful foreclosure.
Your Honor.
Okay.
If we're keeping that last sentence in, the sentence that reflects on page 20, I'd like to add amount of any money damages, comma, if any, comma, that she saw. A good case law, Your Honor, that the jury is allowed to award zero in damages, and we don't want to imply that they have to award some amount.
Yeah, and I think that's recognized in the by the Court of Appeals, the Zong opinion. So I'll include that. Page 20, that would be amount of any money damages, comma, if any, comma, that she suffered.
Thank you.
All right. Hearing nothing else, I'll move on to page 21. We have a just pattern charge here that may or may not be applicable, talking about principals and agents. Any, maybe this was requested. I don't know offhand. Plaintiff, anyone want this in?
I'd like it in.
Any reason we don't think it should be in?
Well, this seems like it's a the kind of instruction that you use when you've got a vicarious liability issue. Obviously PNC has employees who work for it, but this instruction is not necessary to establish that. So we don't think this needs to be included in this case.
Yeah, is there any, there's been no distinction here between any employee or someone acting on one of the bank's behalf as being merely an agent versus a principal. They're all under the same umbrella. I don't think that's.
Well, we've also been talking about Wells Fargo to PNC to McCurdy and Candler, for instance.
Okay.
Page 21 doesn't seem relevant to any actual issue in the case that the jury needs to decide.
Well, his counterpoint was that this principal agent relationship may be relevant between Wells Fargo and PNC.
Which was admitted.
Again, the issue, the standard being slight evidence.
Your Honor, there's, right, well, it's captioned negligence in my understanding. And Mr. Haidari was just talking about how wrongful foreclosure and negligence are different things. I don't know if the caption goes in when here's the final version.
No, it does not.
Okay.
And I think that was his position. I think I disagreed with him. It seems that negligence is part of a tort of wrongful foreclosure. So to that extent, I don't know if I'm with you there.
I'm
Is there
okay
anything
with the,
else about this sentence that you think there's not slight evidence of?
I think the evidence that's been presented so far contradicts the idea that PNC was acting as Wells Fargo's agent. I think it entirely contradicts that. There's no evidence that they were acting as Wells Fargo's agent.
Yeah, I think this really confuses the PNC Wells Fargo issues and is dangerous because of the default status and the fact that the banks are in different postures.
Yeah.
So it accomplishes nothing on the one hand for plaintiff and it creates problems for defendants. I think it should come out.
It's dangerous for both defendants.
Sorry, I couldn't get that.
So I said it's dangerous for both defendants, but for different reasons.
Your Honor, not only were these facts admitted to, but in Wells Fargo's motion to open default, for instance, where they tried to come back and assert an answer under oath, they admitted that PNC was acting as its agent. And similarly in
Well, was that actually, did that make it into the evidence?
that part did not, but the PNC part where it was, where, I forget his name, but Mr. Olson was testifying about sending out the notices and who the parties are and how the notices were being sent for PNC and Wells Fargo, which I had to recharacterize after Mr. Tobin's objection. So I do think that there was discussion of that.
Remotely inaccurate description of the testimony. There was no testimony that PNC was acting on behalf of Wells Fargo. There was testimony that a letter that PNC's foreclosure counsel sent said Wells Fargo Bank NA 2004-12, which is, there's also been testimony that's not a legal entity, and there's certainly no evidence that refers to Wells Fargo.
That's critically important. I mean, that's critically important. Wells Fargo Bank NA, Mr. Dillon, Mr. Howard's client, does not appear on any documents. It's an altogether different entity. So this has the potential for serious confusion. We would object to its inclusion.
Absolutely.
Okay, I'll just, since you raised a new issue there, Mr. Haydari, last word here. If there's anything in responding to
I
that.
believe some of the questions and some of the issues that have come up include who PNC has been acting for, which has been Wells Fargo, and then at some point it's been Wells Fargo GSR, whatever that is. When I was questioning Mr. Olson, he was testifying who he's acting on behalf of. So I believe that's sufficient to establish the agency link.
Okay, I'll put that one alongside the other request. And let you get back to you. Your objections on either party, for both parties, whether it's in or out, are preserved. Page 22, we already addressed, it'll be moved up. Page 23, contracts, since this is not I thought this was not a contract case, since promissory estoppel isn't formally a contract issue. And so I believe I would strike 23, page 23. Then we move to 24, defendant's request to define promissory estoppel. That's also one that we've got some pattern charges on in 25, so we can see what we think about that. Well, actually, there's a distinction here. So 24, plaintiff has not alleged a promissory estoppel claim against Wells Fargo. Is there an objection to carrying that sentence into elsewhere?
That's okay, Your Honor. That is correct.
We propose this as a good introduction to the promissory
Mhm.
estoppel instructions. So we think it is that. So certainly PNC's view that.
Okay. All right, I agree with the first paragraph. Second paragraph, I think we start getting into argument. So I would keep the first paragraph, strike the second one. All right, moving on, 25. Then we get into the patterns defining promissory estoppel. We've got the defendant's request, we've got the pattern charge. I kind of like numbering the elements, so I would keep in the numbers. If there's no objection, then I would strike the pattern charge for promissory estoppel and keep the defendant's request that has the numbered elements. Obviously, in our combined version, we're striking all the citations and that sort of thing.
Your Honor, I would like to keep the pattern charge for promissory estoppel about the injustice.
We've got it in ours too, don't we?
I think he's got it on in point 4.
Point 4.
And it's very similar to the language you have in your requested charge right below it, if not identical.
It looks identical.
Except Your Honor, ours does references that the promissory estoppel claim is against PNC, which I would obviously.
Right.
That's fine, Your Honor.
Okay, so we're striking the pattern charge, we're striking plaintiff's requested charge on 25, we're keeping defendant's requests on 25. Moving on to 26. Defines promise.
These are just important. I mean, promise is a term that's, we're all very familiar with, but in the law, it means something specific. So we think it is important to instruct the jury on what promise means for purposes of establishing whether my client can be liable. So that's why we put together this instruction, and we think it's appropriate.
Is any position on whether this is a correct statement of the law or not,
Your
Mr.
Honor.
Hadary?
This also appears to be argumentative.
Which part of it?
PNC cannot be liable based on an implied understanding or a misunderstanding on the part of plaintiff. Rather, PNC can only be liable if PNC made a
Yeah. So I do think it's starting to place a little bit too much emphasis on the arguments of counsel. What I would propose doing is stopping after the promise will be in effect. So before there's specific references to PNC, it is going to define what a promise means in this context a little bit more about vagueness, indefiniteness, specificity. But until we start using that PNC language, that's where we would stop.
I'm okay with that. Thank you, Your Honor.
Moving on to 27. Then we have some things about reasonable reliance.
Once we get to in determining whether PNC should have reasonably, I believe we're getting into argument.
Mr. Tobin, you want to be heard on that? Otherwise, I would just kind of in the pattern or in the proposed charge there, give it up to that point and strike the rest.
I'm sorry, Your Honor, can you tell me again where we'd be stopping?
Sure, it would stop after these, right at the 5th line, ending in plaintiff in fact reasonably relied on the promise, period. So everything from indetermining onward.
Okay, Your Honor.
All right. 28, we've got the avoidance of injustice.
I'm okay with the first paragraph, Your Honor. I think second paragraph gets a little.
Yeah, that's getting more into policy and again, more things great for argument, but I'm not entirely comfortable with that being as part of the pattern charge. And I also wonder if we even need that just bare sentence when we've already got that outlined as one of the 4 elements of promissory estoppel. I'm not sure what that adds.
I concur.
So with that, with hearing nothing else, then I would just strike page 28. All right, moving on to 29, we're getting into damages. We've got a pattern instruction on damages. It appears applicable, and I'll give it as written there. We have the pattern charge on nominal damages. That doesn't appear to require any alterations. Page 31, we have the duty to lessen. If there's no objection here or thoughts or input there, and we believe it's applicable, I'll give it as written. Don't see any alterations. Probably. Yes, I just it said with 30 that it appeared to be the pattern charge without need of alterations. Okay, we've got, now I believe we're on page 32. Pain and suffering, generally and mental. It appears to be a pattern charge. And if there are no other input, I'll give 32 as written there. 33. This is future pain and suffering. I don't believe it was requested by either party.
We don't think this is appropriate, Your Honor. I mean, we've got, no foreseeability problem. The tort that's alleged in this case obviously occurred 12 years ago. There is a limit, a temporal limit to how long a defendant can be subject to damages. I think we've already far exceeded it.
And what's the authority? I'm just curious, what is the authority for that? When's the stopping point for future pain and suffering?
It's the old Paul's graph for foreseeability.
Yeah.
We all read about it.
But then that's an issue of fact, right? The jury in their enlightened conscience gets to decide the stopping point.
Well, not if it goes 10 years, 15 years, 20 years. I mean, how long is Ms. Zong truly emotionally distressed because of the foreclosure on her property in 2012? I think as a matter of law, that would have stopped a long time ago. So
Yeah.
future pain and suffering from here should not be permitted as a matter of law. So we would object to include.
Okay. Mr. Adari?
This all falls into the enlightened conscious and they get to consider it all.
I mean, if this was a, death case or a broken leg, the jury would just get to consider whether for the rest of their life they're entitled to damages for future pain and suffering. And I think you've got your arguments to preserve it. So noted over the objection, I'll give page 33 written. We've got 34. This may not be as applicable. I don't think there's any allegation here of pre-existing injury or aggravation, but maybe so. Any opinions from the parties on whether I should give 34?
First sentence, Your Honor. I mean, I think that's certainly accurate. I don't know that it's not repeated elsewhere. It's not a pre-existing injury situation, but certainly she shouldn't recover for injuries that are not connected with wrongful foreclosure versus all of her other.
All right, so you're requesting the first paragraph on page 34? All right. So I would strike the second paragraph. That seems more focusing on physical injuries of the personal injury type, and give the first paragraph. All right, page 35. Peace, happiness, and feeling. If there's no objection from the parties, I suppose I would give this pattern instruction as falling under emotional and mental anguish.
Right, I don't think we need even more instructions on language. I think we've covered what Court of Appeals has recognized that mental anguish may be a recoverable category of damages. That's the specific phrase that they use. If there was a mental anguish, it was emotional distress. Those two concepts are covered in separate instructions. So adding in the third surprisingly squishy concept, peace, happiness, and feeling, I think is inappropriate and gives the jury just license to imagine something. I think this is not what the Court of Appeals has said is permissible.
But also, Your Honor, I would point out that the very first sentence says, in a tort action in which the entire injury pertains to the peace, happiness, or good.
This is kind of an interesting pattern charge to me. Does anyone have any context for this or background of where this comes from or its origin?
Yeah, so, well, origin, no, but in a lot of cases where someone has been harmed and it's nebulous and we're not dealing with factual action, something along those lines, a plaintiff can always request just their injury to peace, happiness, and feeling. And what that might be is whatever the jury might decide.
Okay. Well, I mean, I do think that's kind of already been covered. I don't know if those words made it into the complaint somewhere as its own kind of separate vehicle.
I believe I specifically quoted that in our pretrial. It's also been something that I've repeatedly asserted throughout summary judgment, throughout our claims for damages, interrogatory responses, because it's such a nebulous thing that a jury has to award. Knowing that, I included that.
Your Honor, if Mr. Haidari wants to stipulate that the entire injury pertains to the peace, happiness, or feelings of the plaintiff, then I'd be fine with withdrawing my objection.
And I think the jury should be able to decide what they feel occurred. And if that's the entire injury, then that's up to them.
Tire injury.
I think that's incorrect. I mean, I think this statement is pretty clear. Mr. Howard is correct. I mean, I joined his objection, which was much better stated than my own. The only plausible or viable basis to give this instruction is if the tort is one where the entire injury pertains to the peace, happiness, or feelings of the plaintiff. And that's not the case here. So this should not be given.
It's not the case because
Emotional distress, harm to credit, attorney's fees, punitive damages. He's seeking other categories.
but the jury could well find that 4 out of 5 don't apply, and all that's left is the emotional mental anguish. I just see this as almost falling underneath the emotional mental anguish. It's just another way of phrasing it. I'm going to take a closer look at it. I'll let y'all know. Page 36, we get to damage to credit standing by the defendant's request. I don't really see any issues with this one, so I would give it as proposed by the defense.
I'm sorry, Your Honor. Did we skip, oh, let me see.
We're on page 36 now
Thank you.
on damage to credit standing as proposed by the defense.
Your Honor, it's a perfectly good instruction if the images are found to survive our directed verdict motion. So we did raise this in directed verdict. Depending on the judge's, on Your Honor's decision on that, I think would determine whether this is, of course, if we don't prevail, then this instruction would be appropriate.
I'm okay with,
Okay, I'll give that as charged. And I think
Sorry, Your Honor, just for the record, I know I partly submitted this, but I think that the first paragraph is unnecessary. Sort of leads into the remainder of it, so I would ask that the first paragraph be stricken. And obviously, the second paragraph hinges on your decision on both of our motions for directed verdict.
so. On that point, I think what I tried to make clear was that the intention was not to, that I was going to be reserving those until after I get to hear what the jury has to say about it. So I don't plan to issue a ruling on that before they tell us their light's on and they're ready to go. As for that first paragraph, essentially just saying it's duplicative of what we've already heard.
Yes, sir.
All right. I think I am seeing that here. So I'll strike the first paragraph. We'll have the second.
Possible they now want to go.
I'll ask them, but we'll see. If nothing else, we could at least get 30, 40 minutes of a closing started. Well, let me finish the charge conference, and then we can work on that before we're going to at least get some of this closing started. All right, mental anguish on page 37 appears to have already been covered. So I would strike 37. 38, we already covered nominal damages through the pattern charge. So I'll strike that. Page 39, we have damages on promissory estoppel. Essentially just trying to make it, I guess, trying to shed some light between this claim and the wrongful foreclosure claim. So any issues with me giving 39 as alleged or as written?
no, Your Honor, although it does sound duplicative of what we discussed up top in terms of promissory estoppel.
So I would combine this, well, no, let me strike that. All right, for now, I'll plan to give the paragraph in its entirety. Just again, I think the distinction is important between the two claims and the damaged vehicles. If there's another spot I think it may fit better, I'll keep an eye out for that when we see it all together. Page 40, we've got the pattern charge on apportionment. Do we need to keep in the parenthetical of any non-party? All right,
I
striking.
don't believe that apportionment has been preserved in the pretrial, Your Honor, so I don't think apportionment is a proper charge. We addressed all the facts to be considered, and apportionment was not one of them.
We raised it, Your Honor, when we submitted.
These instructions.
Yeah.
Okay.
Or verdict forms.
And I don't know if that's really, if it's just a statement of law, I don't know if that's really something that has to be explicitly preserved.
I believe it might be, and I might have to research that.
All right, well, if you can present authority on that in the next few minutes, I'll take it under advisement. All right, but otherwise I'll be given 40 as written. 41, we have the pattern charge on punitive liability. I don't know why imposes in a parenthetical. I'll just strike the award. I'll strike the parenthetical impose. You can award punitive damages and give it as written. Page 42. We have the clear and convincing evidence pattern charge. Doesn't appear to need any alterations. I'll give it as written. 43. This is the attorney's fees request on behalf of the plaintiff.
The definition of bad faith, Your Honor, and I'm not sure that made it into.
We don't have it. So I would switch the order first of all. I would put page 44 on the front end. It starts off with, in this case, plaintiff seeks additional sums as attorney's fees and costs. I would strike 43. That doesn't really seem to add anything and is duplicative of 44. And to the extent to start talking about specific expenses, I think we've determined those are coming up in part 2. Page 45 is where would be the good spot for a bad faith definition.
Yeah, we have it in page 37 of our draft charge. That's the litigation and attorney's fees. Yeah, we've got the definition from Marta B. Mitchell. Attorney's fees based on bad faith or for conduct that shows a dishonest purpose and implying basically the law that I was articulating or trying to anyway in the directed verdict motion. So we do need to define bad faith if this is going to.
Do you have that definition of bad faith in front of you, Mr. Hadary?
I believe that's one way you can show bad faith, but there's different ways to show bad faith.
So where's your proposed definition of bad faith? Can you email it to me? Or show it to me. We got it on the chat.
I don't believe we should actually define it in the pattern, Your Honor, because there's different cases that have different ways they find bad faith. And so I'm worried that we might be limiting ourselves.
Well, we need a definition. They have to know what bad faith means. And Marta V. Mitchell provides the definition for Georgia law. Attorney's fees based on bad faith or for conduct that shows a dishonest purpose and imply conscious wrongdoing or some motive of interest or ill will on the part of the defendant. Their negligence in the performance of a contract is not established bad faith.
So this is page 30.
That's from page 37 of defendant's requested charge.
Page 40.
Was 40?
Yeah, it's 40. This version. I don't know what the difference is, but
Okay,
it's like it's on page 40, Your Honor.
so. Same thing.
All right, so we'll have the statutory definition already where it talks about bad faith, stubbornly litigious, or cause unnecessary trouble and expense. And then to further define bad faith, I'll accept the defendant's proposal here where it talks about attorney's fees based on bad faith, that sentence, and the second sentence, mere negligence. Turning back to our proposed packet, 45 and
Sorry, I have a
Sure.
quick question on the page that was previously marked as 44 of 49, or it's marked as 44 of 49. It says that attorney's fees plaintiff has to show them by the preponderance of the evidence. I think there's a higher standard than that. Unless somebody wants to tell me incorrect about that.
No, it is preponderance of the evidence. You only get the clear and convincing when you're dealing with punitives and some other things, but
From my comment.
all right, then we were on 45. This was a plaintiff's request. I could tack this last sentence onto the end of the bad faith definition if there's no objection from the defense.
Well, we don't think this definition of bad faith is consistent with what we're using. Is it? Actually, no, I'm sorry. They're separate concepts. It's different.
All right, so the second sentence of this, I would add to the end or within the definition of bad faith, kind of combining this and the defendants. And without objection, I'll include that. 46 being the slight evidence.
Oh, that's kind of.
Yeah, I don't see that as, that's not a, all right, 46, I can note your objection for the record, Mr. Hader, but I don't see that as
thank you, Your Honor.
appropriate for a pattern charge. 47, pattern charge on court's interests. 48, sympathy pattern charge. And then 49, the final instructions pattern charge. Anything else to note for the record?
No, Your Honor, thank you.
No, I would like to just note for the record that we think it would be appropriate to give an instruction to the jury that based on the U case, that the only requirement in the foreclosure notice is that the party with power to negotiate with the borrower needs to be identified in the foreclosure notice. That's a principle that's been recognized in a long string of Georgia cases. So I'd like to make a record of the fact that we think that that concept should be included in the jury instructions.
Can you say that one more time?
That based on the U versus JP Morgan Chase case,
Was this in your requests?
it was not in that.
Okay.
So I am just making record now. So
Okay.
That there is a concept that the only party that needs to be identified in a foreclosure notice is the servicer. And we think the jury should be so instructed.
Okay. I didn't see that as being one of the plaintiff's main complaints here. It was identifying the wrong, as it relates to PNC. There's been no debate that PNC is not the
I
servicer.
think the testimony about that yesterday, Your Honor.
Okay,
So that's what prompted the interest and the concern.
okay. And you want to say anything for the record, Mr. Hader?
I'm not exactly sure what the request is. I don't believe that's necessarily a fair characterization of viewed and not, I think it is, to be quite frank, quite confusing.
Okay. All right. Well, as the record has been made. So let's take a break here. I'll inquire if the jury still wants to hear, 35 to 40 minutes of closing, probably more likely 30. And we'll get this consolidated copy to you and go from there. So we're in recess. Lost Deputy Scott. Thank you for hanging in there. We're almost there.
Does that count as? So it's possible that in it's into the record, it's. It doesn't count as. Oh, I think I did see one case that says that preserve means that the party actually needs to object to it. Oh, there, it says, the appointment statute was not preserved because no objection was made. Following the rule.
What do you?
This is just, I asked the Lexus and I don't understand. You just go.
You use Lexus too?
I did.
Oh.
I did use.
Westlaw.
No, I've gotten used to Lexus.
I like Lex, I'm a Lexus person.
Yeah, you and Evan E1.
You
I
won.
thought you won like Westlaw. You won Westlaw.
He's Westlaw boy.
You're Lexus.
I use Westlaw only when I search the case notes following the statute. Westlaw is good for that.
Lexus is Brad. Westlaw's here.
Okay. Very cutesy.
32.
Very
One second, don't lose that page.
Yeah, it's on Google Doc.
What's the statute 5112?
What's that?
What was the statute 5112?
511233.
Got it, thank you.
That's the apportionment. If the court concluded apportionment will fall, including intentional was required under 061. We're going now.
Hey.
Yeah, my wife's eager.
So when is he deciding the? After he comes back.
He just said he wants to hold on to it. He doesn't want.
Nice and warm.
Oh, yeah, that's right. That's right. Yes, you're here, just remind me.
Yeah.
I got COVID over there. I just spent like 2 weeks in Dublin.
You got COVID when you couldn't.
First 2 days weren't so great, but after that, I was like, oh, it's okay.
I think if you got way better.
I don't think it was fun.
It's like COVID. But it'll also focus them.
That's what that was the calculus. I landed on letting them waste their time on it.
I didn't really have to email me that case. Thank you.
Your Honor, were we going to discuss the verdict form as well, or what's?
Good point. Do you need that before you get started?
I think it would be useful.
Okay.
but we can discuss it tomorrow as well. I mean, if
Okay. If there aren't any concerns before you would start your opening closing, then let's do that. All right, back on the record here. We'll have that consolidated version emailed to you shortly, but on the three outstanding issues, the first was on our draft version, page 19, the final two sentences talking about once a foreclosing party properly mails the notice, whether they actually receive the notice. I think that's a true statement of the law. The operative word is properly, and that can be argued by the parties in closing. So I would, I'll include that. On the agency and principles, I'm looking at the statute and, you know, whether someone was an agent here or a principal. I think that's something that can be argued by the parties. And so it's a true statement of the law. I think that there's at a minimum some slight circumstantial evidence that it could be argued in some way. So I would include that. And with the peace, love, and happiness, or however it went, again, I think the plaintiff is allowed to bring alternative claims. And so a jury could very well reject the ones that are not that and still find that through that means they're entitled to consider damages through their enlightened conscience. So it being a pattern charge and it appearing to be applicable here, I'll include that as well. So with that, is there any reason we shouldn't bring in the jury and get started? Mr. Haydari?
no, we can get started, but I would request that we can look at the verdict form, perhaps maybe when tomorrow morning
Or they really want to get out of here at 5.
Or after
So
5.
the second we let them go, we can just start talking about that.
that'd be great.
All right. So red's going to be you, Mr. Haydari, and whenever you start talking, it counts down from 2 hours.
Okay, I appreciate that.
All right. Let's bring in the jury.
Your Honor, just so you know, my colleagues can argue opening.
All right.
I'm gonna
Fantastic.
like 5.
Oh, you only want 5 minutes.
Maybe 10.
Okay.
Or 20.
See.
We'll see.
We'll see. I get carried
Well,
away.
in that case, I'll put on the one for the other folks. Have y'all, as I understand it, it's by, not by party, it's by side. Are y'all have found some division between the 2 hours?
I'm just, so the notion here is that claim's gonna go for 5 minutes and then it turns over to us? That's what?
I don't quite know what they're saying. Is that what?
Something like that. We're gonna have opening remarks and
We're
then
gonna have 2 different attorneys for plaintiff speaking? Is that something that's, I've never seen that before, is that?
That's for the jury.
Let's see where we go.
Good, President, Your Honor.
Thank you, Deputy Scott. Thank you, members of the jury, for your patience. We're now ready to begin closing arguments. The plaintiff, since they have the burden of proof, has the right to open and conclude closing arguments. And so is the plaintiff electing to begin closing arguments?
Yes, Your Honor.
All right, the floor is yours.
Hey, everyone. I'm Evan. I may have haven't heard from you all. I've been sitting there listening to everything just the same as you all. I've been confused at times. I've been tired at times. I get it. We're all human. Everyone in this room is human. But y'all are here to fulfill your duty as true. What the duty means is to look at all the evidence we present to you, and only that evidence. Including those facts. What kinds of people on it. Your first duty is to see if more likely than not, PNC wrongfully foreclosed on Faye's home. Faye has 2 rights of recovery here. Did PNC give Faye proper notice? No, they did not. Did PNC tell Faye that if she made $3,800 in payments, the situation would be resolved? Yes, they did. The next issue for PNC is to see if in that process of modifying the loan,
in foreclosing if they acted with bad faith, stubborn litigiousness, or cause Fay unnecessary trouble or expense. Obviously, my position is yes. Next, promissory estoppel. You've heard that term. The next item you have to see is it more probable than not. He made a promise to Fay that she relied on reasonably. The PNC wrote. What that promise is, as I referenced before, hey, Fay, make this approximately $3,800 payment. The situation will be resolved. The only clear answer she ever got from PNC to that was, here's the coupon book. Make these payments. You've heard a lot of testimony, you've seen a lot of letters, there's confusion. The document that they sent showed make these payments. That was the only document they sent that said make these payments. Okay? That they could explain the reasoning for that she relied on. She tried to do just that. She paid multiple payments over the course of 2010 in full. And remember, I think it's important to remember too, she paid on time every payment. And still this escrow analysis happened. It wasn't like she was delinquent in 2005, 2006, 2007, 2008. This came up, it was an issue. She was confused about what happened. She tried to figure it out. And that's when they claim that she missed 14 payments. But you also heard of all the checks that she sent in that they kept. They're trying to have two bites of the apple in that way. Now, as to Wells Fargo, liability against Wells Fargo is already established by law. It's not a question for you whether Wells Fargo committed wrongful foreclosure. It's not a question for you whether Wells Fargo had bad faith, whether they were stubbornly litigious, or whether they had caused Fay unnecessary trouble and expense. The only question to Wells Fargo is what amount of damages did they cause and what amount of attorney's fees do they owe Fay, not whether they do. Was Fay hurt by this foreclosure? We presented evidence to show that she was. You heard from her son. You heard from her sister. You heard from her niece. You heard from Fay. She lost her home. She lost her confidence. In return for those losses, what did she get? Anxiety, depression, distance from family. She felt like she failed. She felt like she gave everything that she could. She did everything that she thought was right. But it wasn't enough to keep defendants from taking her home. And that hits you deep. When you get everything, but PNC still doesn't believe that Fay deserved an explanation. What did PNC do when Fay was calling them? When she was giving her all? She called them regularly. There's no dispute about that. There's no dispute that she was calling, trying to figure this out. This is not a case where she got these letters and then just set it aside, put them in the shredder. She was trying to figure the situation out. As the evidence showed, as recently as 3 weeks before the foreclosure, PNC asked her for hazard insurance proof that she sent. She thought she was still working towards a resolution. At the same time, they were transferring the deed to foreclose in her house. They couldn't give her a straight answer. Now, after the benefit of 12 years of litigation, they have some explanations. They tried to explain their conduct. Y'all, none of that was given to Fay at the time. She didn't know any of that then. They didn't explain it to her. You heard about the single point of contact? Go back, look through the call records, look at all the initials. It's different people. There's dozens of people working on this file. It's not like you have Amber at PNC that you're calling to try to figure this out. There's not someone looking into this regularly. She was confused. They made it confusing.
They wanted the process to be confusing. They were trying to double dip on the taxes. They wanted her to pay the full tax amount. The full tax amount, and then also make monthly payments to make up for that same tax amount. $10,000 in tax payments she missed turned into $40,000 that she owed. So she hired an attorney. He contacted PNC. He said, hey, I'm her attorney in this dispute. She retained me to help figure this out. Send everything through me so we can get to the bottom of this. Looking forward to working this out. It was hopeful. Wanted to resolve it. What did PNC do? They didn't give her attorney an answer. They didn't explain their calculations. None of that. You heard this from yourself at trial. Oh, we didn't give Mr. Hidari the information because Faye didn't check the right box on a form. First of all, the box she checked on the form states she can share information about loan balances, repayment, all of that. I want you to look back at that for yourself, read the language in that, and you can decide what that means. What's reasonable from that, the box that she checked. By the way, at the time, no one from PNC told, hey, Faye, if you actually want us to talk to your attorney, resubmit the form. They didn't say, check this other box. That didn't happen. But even setting that aside, they ignored all the letters from Mr. Hidari saying, hey, I'm Faye's attorney. Is that what we expect banks should do? Do we want them to ignore letters from people's attorneys? That's a pretty weak position. They know that. Why are they taking that position? Because they have to. They have to. They know that they should have sent notice of the foreclosure to her attorney, as required by that statute that you saw. They have to send notice to either, they have to send notice either to Homeland or to any other address which the borrower signifies. Through her agent, Mr. Hidari. Hey, send me everything about the foreclosure. Send me everything about a loan modification. I'm handling this for her. They've also tried to paint Faye in a bad light. Oh, hey, even if we're liable for wrongful foreclosure, look over here, this totally distinct and separate case. That's what caused that's what caused Faye's heartache and loss. That's what caused her stress. You heard evidence to the contrary, though. The other case was settled. Faye was happy. It was done with. You heard that from Faye. You heard that from her son. Another argument they made. Hey, even if we wrongfully foreclose, this house wasn't that before they were. The house wasn't that before. She wasn't even living there. You heard why, though. You heard why. She rented a different house so she could take her daughter to a special art program that her, I think, 11-year-old daughter at the time wanted to go to. The house the 700 Latour Drive house, she rented that out for $2,300 a month, less than what was due on her mortgage. It wasn't because of finances. She wanted to take her daughter to the art school. But what did they show you? What evidence did they actually show you to show that she didn't care? I'm sure you saw that emotion that Faye's son had, Jason, that he had on the witness stand. I'm sure you saw the emotion that her sister had, that her niece had. I'm sure you saw the emotion that Faye has had during this entire trial. In this courtroom, while His Honor may be the judge generally, you are the judge of credibility. You look at who's on the witness stand, and if you believe them or not. Do you believe Faye? I didn't know Faye before her home was taken. I didn't know her when she was a home builder. I do know her now. I've seen the pain and anxiety. She's lived it for more than 12 years before I even began law school. They owed Faye a duty. They breached it. PNC made Faye a promise and they broke it. I know you heard a lot of details about her house. A lot. She remembers all of that though. That was her house. That was her dream house. You know, she had dreams and she's left with nightmares. There may come a day when you forget about being in this case. It may be a day where Mr. Tobin or Mr. Howard forgets about being in this case. And regrettably, I may say there may be a day that I forget about being in this case. I guarantee you, Faye will never forget about this case. Thank you.
Ms. Stone, you want to approach with counsel?
Again?
Do you want to approach with counsel? Or do you want to get into it?
That's fine, Your Honor. I do have a suggestion I want to make, so.
Yeah.
Exhausted.
All right, members of the jury, I have received assurances from counsel that they do not intend to use their full time for closing arguments. And again, as I've said from the beginning, these trials aren't scripted things. And so there's so much that comes up that we have to address and we don't know how long it's going to take. So I thank you again for your patience. I believe that the best use of everyone's time is that we're going to be able to pick this up and resume closings at 9 a.m. tomorrow. We're going to go right through those. And when we conclude, it would be lunchtime, at which point I would charge you on the law. And then the time is yours. And like I said, we're going to order lunch for you. You don't have to, if you don't, you can still pack your own or leave if you want to. It's your decision. And you can choose to work through lunch if you want to, which is, again, your call. So if there aren't any other questions or concerns now, I'll leave you with the regular instruction of please don't do any research about this case or discuss the case with anyone, including amongst yourselves. Thank you so much. We'll see you at 9 o'clock tomorrow. All right. Thank you, Deputy Scott. All right. So a few things I think we need to go over. One, right before the jury came in, just to clarify, my understanding is that, again, this may not be an issue, it may be, but I just want to make sure we're all on the same page, is that I've got my countdown clocks and that the 2 hours applies collectively to the defense. So that's something that the defense would have to agree amongst themselves how to divide that. Is that accurate?
That's fine.
All right. I just want to make sure we're on the same page. And again, I have seen attorney teams divide the opening and closing arguments, so I didn't see a concern there, to your point, Mr. Tobin. I know we still need to address the verdict form. Other than that, what do you think the agenda needs to be before we break for the day? Any suggestions from the plaintiff?
The verdict form, Your Honor.
Anything else here, Your Honor?
House, Your Honor.
Okay. All right. So I've got the one submitted by the plaintiff on Monday, and I've got the one, I believe the most recent, submitted by the defendants jointly. One of the differences between the two, I would say, is that the defendants goes through every single element, and the plaintiffs doesn't divide up the damages. So I think I'm looking to combine the two. And so I would like the damages to be divided up versus nominal versus mental anguish. Yeah, versus maybe even, I think credit was how we also had it divided up on the defendants, if I'm not mistaken.
Dan, do you mind emailing me your last version?
Yeah, we emailed it on August 20th. So if you find an email from me on August 20th, it should be there.
Forwarded to you.
And so again, from I think the defendant's proposed one, the part about whether Wells Fargo acted in bad faith according to attorney's fees, I think that would be taken out entirely, and we'll address, the second round verdict form when we get there. But other than that, any other general thoughts or arguments or input about how this verdict form should look? As I've said, I would like to divide out damages. I don't know if it kind of doubles the length of this thing, or makes it 4 pages if we go element by element by element. And so I don't know if I see the utility of that. I do see the utility in dividing it by claims. So it'd be yes or no, are you liable on wrongful foreclosure? Yes or no, are you liable on promissory estoppel? And then proceeding to the, writing down the damages amounts. So I'll open the floor generally to any input on that.
I'm okay with that, Your Honor. I think it's easier to just have one number, but if you want to split it up between nominal, well, I do think that we shouldn't break it up in terms of mental anguish and credit, because I believe that it should be nominal and general, whatever those general might be, because if the jurors heard something and picked up on something that perhaps they believe is, just to give you by example, my client's son mentioned it, she looked like she aged 10 years or whatnot. And that might not be a mental anguish claim. That could be something else. That's a general enlightened, conscious, and impartial jury award of damages. And if we come back and say that's solely mental anguish, and I think that pigeonholes them in a way that they're not supposed to be pigeonholed.
Okay.
Your Honor, I don't understand what the claim is. The claim that she was actually transported 10 years older, like literally? I'm sorry. I just think that's by definition a mental anguish claim.
I took more his point. I took his point more to be that there's some intermingling. And so if that's the case, it would have confused the jury if they think that some aspect of damage is both bad credit and mental anguish. And if so, how do we make that clear on the verdict form so that we can distinguish between them?
At this point, we just simply have a question for each defendant, and you think that should be broken down further, but so we should have sort of a breakdown for the damages, but not for the liability?
Well, look, if both parties say they don't want it broken down by the measure of damages, then I'll go with that. That was just one thought that occurred, that if, you're saying that potentially you've got these issues, legal issues that you might be litigating further about a specific claim. Maybe it might be worth delineating that.
That does make sense. Yeah, well, it does make sense. So the two categories would be emotional distress and harm credit?
And the punitives, but that's, round 2, but yes, essentially.
And just to follow upon what Your Honor said, I think it's a little nebulous because there might be things the jury pick up on that might be outside what they feel is mental anguish or damage to credit. And not to mention, in terms of damage to credit, is that part of a mental anguish claim? Is that the fact that she's no longer doing what she used to do? Is that mental anguish, or is that damage to credit? Is that both? I think.
Well, one thing comes to mind, and this is just me brainstorming. So it would be that each is individualized, and then there's some kind of direction that those two should then be added together by the jury for the total amount. I guess kind of suggesting to them that they're going to list a total amount, and so there's no confusion of us that they're wanting them to be duplicated in some way. If that, and again, I'm just kind of speaking off the cuff here. If you catch my drift.
I mean, I think it does make sense to be specific what they can recover. I mean, Mr. Hadary just suggested that maybe they'll award damages for what she used to be able to do, but can't anymore. That sounds like business damages, which have been specifically excluded. So I think we should be specific about what they can award compensatory wise on wrongful foreclosure. And I think we have identified the two categories, which are mental anguish and harm to credit. So breaking those two out, and if you want to provide a total too, that sounds fine. And I think it would be pretty easy to adjust number 5 on the defendant's form. And by the way, Your Honor, I have to say, I apologize, but this doesn't look like the last version of the verdict form, and I take responsibility for that because I just said August 20th, and I know this is what, but I remember Mr. Howard and I worked on this and we took out number 23. We absolutely took out number 23. So
What are you looking at right now? Did we give you something?
no, I'm looking at what I thought coming in today was the final version of the verdict form the defendants provided to you. But I'm looking at it, I'm thinking this isn't it,
Well, and why do you think that's the one you gave me?
because I printed it out last night and it was something that I sent to Ms. Sue.
Okay.
Yeah, Your Honor, and you had mentioned the paragraph H or 23 that made it look like we were contending.
Right.
On attorney's fees.
You took that out, and I'm looking at things, and we worked hard on it.
Yeah, it's probably, well, no, I mean, that's probably just some emails crossing streams. So can you just tell us again maybe the date and the time thereabouts you sent the most recent?
Your Honor, may my client be excused?
Yes.
Your Honor, just for the record, I do think I will object to limiting it to mental anguish and credit because the impartial conscience of an enlightened jury is broader and it could have anything in there that maybe we haven't even observed, whether it's, lost aspirations or whatever the jury thinks is proper in awarding it, it's within their province. And I think that by limiting them to just two categories is not a proper application of the law.
All right.
We did not come up with a better form, and I can't account for that. Mr. Howard, that worked out a lot.
I have not. But again.
You can still send it now and we're not, stamping anything officially. So.
I mean, I just have to think about what the heck happened here, because, I suppose this. I don't know how it happened, because number 23 absolutely came out. We figured out that that's not something that belongs on this verdict form, but there it is on what we've done. I remember too that we addressed number 5. Yeah, there were two items on the proposed verdict form number 1 that we realized were problematic. One you flagged for us, number 5. At the pretrial, you said, Mr. Howard, you're still trying to argue liability on wrongful foreclosure. And we went back to number 5 and realized, yeah, we need to fix that.
See, and mine are also still numbered by letters. So when you say number 5, that doesn't mean anything to me.
Howard document, Your Honor.
Yeah. But I know what you're referring to. It's on page 5. And then what was the other one?
It was number 23, which appeared to raise the possibility that the jury would have to find that Wells Fargo acted in bad faith, for an award of attorney's fees to be justified. And we realized after we submitted it initially back in June that that needed to change. So I regret that the work that we did is just not shown in what we have here. And we tried to do some searches to try to find a better document, and we were not successful. So we can certainly try to do some drafting on this now. Try, but if your honor wants to take us through what you think should happen to the verdict form, obviously do the work with your guidance in mind. I mean, we did think, I know you had said that you liked the idea of breaking down the elements.
Yeah.
So we thought that the first few questions kind of did set up the rest of the verdict form well.
I'm wondering, I mean, I'm just wondering if we're all looking at the same collective document now. It's going to be hard for us to do, you know. Yeah, so let me look back at the, so just for example, let's start with wrongful foreclosure on the plaintiff's current special verdict form. Is PNC liable? Yes, no. Title to monetary damages, yes, no. Amount. And that's it. And so using that as the starting point, the only thing I was saying to put in there would be, yeah, breaking down the category of monetary damages according to the pattern instructions that we've agreed on. And those categories, I think, were outlined in the defendant's verdict form, which we had one for nominal damages.
We do have, it turns out that the document that we finalized was on Donaldson Systems rather than Allard's ours. So.
All right, let's do this. Why don't we let you take another crack at it? And we can take it back up tomorrow morning. And again, I'd like to see if this is something we can get a joint proposed verdict form on with the objections maintained for the record. But right now, I think it would be valuable to have nominal compensatory, or even if you don't want to classify them as bad credit versus mental anguish, I guess maybe it needs to be delineated nominal versus compensatory. Or
I'm okay with that, Your Honor.
I guess that was his position. I'm going to let you all think through that. This is your case, so you tell me.
I'd like to start at 8, earlier than 9 o'clock tomorrow, Your Honor.
What do y'all want to do?
Here.
I know the building only opens at 8:30, and she's probably about to kill us. So.
Get early in time to go through that and set up. So.
Well, even if it's not on the record, I think we could still at least be having conversations about it. So.
Sounds good.
Yeah. So why don't if the attorneys can be here by 8:45, we can at least see where we are with the verdict form. If you've been able to come up with a joint document. And at least have another working copy for me. So if when you've got that, just email it over, whatever, tonight or tomorrow morning. Anything else we need to take up?